We are live.
Great. Good afternoon. It is the 3rd of February, 2021, and welcome to the House Judiciary Committee. We have 3 bills today. We almost won't know what to do with only 3 bills. I don't know, but several witnesses on a couple of the second and third bills that we have. They are all going to be under what we call the 3 and 2 rule. So the sponsors will have 3 minutes. The witnesses for each bill will have 2 minutes. Members, remember to keep yourself muted, Delegate Griffith, and just Delegate Griffith right now. Until you're called upon. Witnesses, you should stay muted until you're called upon, and then we'll be happy to hear from you. For each bill, I'll announce the sponsor and kind of go through the witness list and give a rule of the road for who's going to go first, and try to break them into smaller panels so that we can ask lots of questions. With that, we're going to start with House Bill 668, Delegate Szeliga, and it's just Delegate Szeliga. So we're happy to hear from you. Go ahead.
Thank you, Mr. Chairman. For the record, I'm Delegate Kathy Szeliga, and today I'm presenting House Bill 668, Reckless and Negligent Driving, Death of Another Must Appear. We're calling this Sherry's and Ryan's Law. And this is my first hearing. I only have 2 bills this year. So I had some of my witnesses had trouble signing up. You all should have received an email from my office with additional testimony. Hence, I'm the only testifier today. I don't know if your supporters have had trouble with our system as well. This bill is simple, and you may remember it from last year. This bill simply says that if you are found guilty of negligent driving, you cannot just pay your ticket and not show up in court. You must appear in court and pay your ticket there. And there are, in 2019, there were only 28 cases, thank goodness, where someone was killed in an accidental accident that clearly didn't follow any criminal charges. And in 2020, there were 27 of those instances. And you may recall that the bill hearing, I know we have so many, but last year I had a family come. There was someone in a wheelchair, and the mother and wife had been tragically killed in a motorcycle accident. And they had hoped that the person that caused the accident would have come to court. They could have seen them, they could have gotten some closure. And, you know, studies will actually show this is can be a very healthy thing where parties on both sides can find closure to this kind of horrific accident. You'll see on the witness list that I have ABATE, and clearly the motorcycle community is behind this, but also bicyclers as well. And I'm sure there's pedestrians that have also been affected. Additionally, AAA, American Automobile Association, for some reason, their testimony did not load either. And I would point to our Baltimore County State's Attorney, Scott Schellenberger. You know, he says in his testimony that it's a simple fact that all state's attorneys know that this is one of the most difficult things for them to tell a family, that these are just must appear, and the surviving family doesn't get a moment for accountability and maybe even some healing. So with that, Mr. Chairman, I'll turn it over to you for any questions.
All right, thank you. Thank you very much. Just to make sure we've got this right. If you get a ticket for reckless driving or negligent driving, these are payable traffic tickets, correct?
Correct. Yeah, only when there's a death, if there's a death involved, and even without a death, these are tickets that the fine can be paid and you don't have to appear.
Right. So the issue is that because you don't have to appear, the victims don't get an opportunity to be heard in court. So there are these fatal accidents that happen, and there may not be any other criminal act on top of it. They weren't driving drunk. They weren't doing anything else. It was just a really bad accident and died. and someone was at fault, but they can just simply pay the ticket and not come to court, correct?
That is correct. And last year, you may recall, we had the court system weigh in with concerns. Over the summer, I did meet with the court system and we heard each other's concerns. And so I was very pleased that they did not weigh in this time. And you can see the fiscal notice just to set up something in the IT program so that they can record these cases as they must appear.
Okay. I did see comments from AAA that were sent to the committee, so they did come to committee members, so you should check your emails for that. And with that, I will stop, and we will start with Delegate Juanita Fisher.
Thank you, Delegate, for this legislation. It was, I was sitting in Montgomery County for a different case, and the similar thing came up before I went up. And what I thought was interesting was the defendant in this case was a young teenager as our children are driving. And the motorcyclist was killed in this turn. She was taking her brother. I remember it because I was just sitting there. She was taking her brother to soccer practice. Good kid, 16. And I think, and the other person died, and there was no, like Mr. Chair said in the beginning, no other criminal thing. So the attorney for the family came to, when you have must appear, your attorney can come for you in way of your appearance. And I just would ask you the question, when it comes to our young people that are driving and sort of their mental stamina and health, I think it was seen that the teenager was dealing with so much that a car accident, led someone else to be killed, to have to come to court and see the other person's entire family was there, and how much that would have hurt the defendant, but the defendant happened to be under 18. So I just wanted your perspective on what this bill would then have on our youth that are driving, that may make mistakes, that may end up in this situation. And I happened to witness that literally a couple of months ago when I was in court. So if you could comment on that for the young people who might be on the other side under 18, having to face that.
Yeah, Delegate Fisher, how tragic. I'm sure there wasn't a dry eye in the courtroom. And, it is, I would say, could be quite healing for the person, the defendant. And Anne Arundel County has actually a program where they put folks together in situations like that. And what they found is that it brings closure and healings for both parties. And so I think that it could be a very positive thing, because you could think of the regret that young person may have as they mature, as they're 30, as they're 40, as they have children of their own, and would say, gosh, I'm so sorry I wasn't able to look at that family and tell them how sorry I was. It is obviously an accident. There was no malfeasance, there was nothing criminal, or they would have been charged. So I think in the long run for the, global mental health, it probably would be an effective tool for both parties.
Delegate Nicole Williams.
Yes, thank you, Mr. Chair. And thank you, Delegate Shalaga, for bringing this bill. I guess my question I have is, and I guess this is a hypothetical situation where you have this situation occur, but the person doesn't pass away right away. And so the ticket, they pay the ticket, but then say a month after the fact or something like that, the person then succumbs to any injuries that they sustained from the accident. Are you proposing that now, even though the ticket has now been paid, the defendant has to come back to court? Or I guess, how would this play out in that particular situation?
Yeah, I would not assume that at all. So, the ticket has a life of a, certain amount of time. You get a notice from the court. And if the person had paid their ticket and, the victim did pass away later, there would be retroactive ability to have them, impose some kind of must appear on them. The bill doesn't say that. So once that court, ticket has been paid and that date has passed, there would be no further obligation.
Okay, thank you.
Are there further questions for the delegate? Seeing none, thank you very much, Delegate Schlega.
Thank you, and you guys have a short day today. Enjoy it.
That concludes the testimony on House Bill 668. We're now going to go to House Bill 508 with Delegate Attar. Again, this is 3 minutes for the sponsor, 2 minutes for the witnesses. There are a total of 16 people who are signed up to testify, including Delegate Attar, I believe. I'll do some quick math here in a second. There are, for Delegate Attar, 1, 2, 3, 4, 5, 6, 7. There's Delegate Attar plus 6. And then there are, it should be 9 more who are unfavorable. What we will do is we'll take Delegate Attar and then we'll hear from the 6 witnesses in favor. Those are Ashley Duckman, Gardner Duval, Mike O'Halloran, Michael Sanderson, Ellen Valentino, Benjamin Seidel. We'll hear from each of them. And then they will each get 2 minutes, and then we will take questions for those people in favor of the legislation. All right. With that, Delegate Attar, you will have 3 minutes. And
thank you, Mr. Chairman. Can you hear me?
Yes, go ahead.
Thank you, Mr. Chairman and members of the committee. For the record, I'm Delia Attar, and I'm pleased to introduce House Bill 508, COVID-19 Civil Immunity. It's my understanding that this bill is the top priority this year of the Maryland Chamber of Commerce, the National Association of Independent Businesses, and the Maryland small business community. This bill is a direct response to the COVID-19 pandemic, which has devastated so many Maryland businesses, both small and large. No business has been immune, and many of them have been especially hard hit. Many small businesses have had to either permanently close their door, or they've gone to extreme lengths to keep their businesses from closing forever. And now, after all this, many businesses face the prospect of having to defend lawsuits filed as a result of this pandemic. And this is just that, a pandemic. We are living through extreme circumstances, and House Bill 508 is a reasonable response to this situation. This bill is intended to throw a lifeline to Maryland organizations that in good faith have endeavored to adhere to COVID-19 guidelines promulgated at the federal, state, and local levels. House Bill 508 is limited to COVID-19 claims that arose between March 5th, 2020 and 180 days after the governor's executive order is expired or rescinded. This bill states that a person who in the exercise of good faith acts in compliance with all federal, state, local statutes, rules, regulations, executive orders, and agency orders related to COVID-19, they are immune from civil liability for a COVID-19 claim unless the person's actions amount to gross negligence or intentional wrongdoing. Now, my attention has been called to the Maryland Court of Appeals decision in Duo versus Comcast. I will leave it to Mr. Duval and my panel to discuss this case in greater detail, but I want to be clear that this legislation, unlike in the Duo case, does not extinguish the rights of people allegedly injured due to contracting COVID-19 at a particular business location to file suit. Rather, what this bill does is to raise the level of proof that must be introduced at a trial for the plaintiff to prevail. And to take it a step further, employees can still file workers' compensation claims against employers. This does not extinguish that right either. To be clear, those who engage in misconduct are still liable pursuant to this bill. Mr. Chairman, members, we are living in extraordinarily difficult time for all. We must find a way to ensure we are not harming those who in good faith were in compliance with the current rules and regulations, and this bill does just that. I therefore ask for a favorable report. Thank you.
Okay, thank you very much. We'll go now to Ashley Duckman.
Thank you, Mr. Chairman, members of the committee. Appreciate the opportunity to appear before you today. And in the spirit of having a short day for you all, I'll try to be brief and yield back some of my time. For the record, Ashley Duckman here on behalf of the Maryland Chamber of Commerce, my 5,000 members and federated partners from across the state in support of House Bill 508. Just to level set, since the onset of the pandemic, my members have remained committed to doing their part to mitigate the public health impact of the pandemic. Businesses of all types and sizes in my membership across all industry sectors including educational institutions, nonprofits, many other types of organizations have been working tirelessly and steadfastly since day one to protect employees, customers, students, and the general public from exposure to COVID-19. And they've been doing that, as the delegate pointed out, in an environment that is often filled with incomplete, inconsistent, or constantly changing information, you name it. So as a result, the private sector has faced potential liability challenges, and the growing risk of opportunistic lawsuits remain a real threat and a real fear among Maryland business owners and my members. The potential proliferation of opportunistic COVID lawsuits pose a real barrier, we believe, in our ability to fully reignite Maryland's economy and truly be on the road to economic recovery. To that end, it's really a gross understatement to suggest that COVID has decimated our economy. Just a couple of weeks ago, the comptroller estimated that more than 30,000 businesses will close permanently as a result of the virus. Those that are left open continue to struggle, often operating at reduced capacity with unsustainable revenue margins. Simply put, our business owners, in particular our small business owners, which you'll hear more about from my colleague at NFIB, simply can't afford to defend themselves from unfounded legal threats of legal action that could end up costing them thousands of dollars. But I just want to be clear, we as a business community are not asking for blanket immunity. We are not suggesting that bad actors not be held accountable. They should be held accountable. What we're suggesting through this bill is that employers following proper health and government guidance should not face the threat of being sued out of business. And our job creators need that assurance that when they do the right thing, when they follow the advice of public health experts, when they take every necessary measure and precaution, they're not threatened by more financial hardship in the form of unwarranted or opportunistic lawsuits. And we believe House Bill 508 would do just that. And for that reason, the Chamber and our members respectfully request a favorable report.
Thank you very much. We'll go now to Gardner Duval for 2 minutes, please. Mr. Duval, who needs to be unmuted.
Thank you, Mr. Chairman. Gardner Duval, bringing the support of Maryland Defense Council. This pandemic has been a unique experience. We all see, and you can look at the length of my hair and see that I'm taking it seriously in terms of being precautious. But what to do has been a year of on-the-fly decision-making in an ever-changing situation. And in that situation, there has been no opportunity for society to determine a standard of due care. We just don't know what to do. We don't know whether to go out, whether to have people in, what to do, how to do it. And so we have regulations. And what this bill says is if you follow the regulations, you can't be sued for lack of due care. Obviously, if you're grossly negligent or engaged in intentional wrongdoing, then you're liable. But this is not a situation where we saw in DUA where the General Assembly looked at a fixed set of legal rights and said, we want to change those rights going backwards. There's no fixed set of legal rights here. In the DUA situation, there's a legally prescribed rate of interest. The rules of the road were set, and the General Assembly said, no, we want to retroactively change those rules. And the court says you can't do that. But here, there are no rules of the road that are set. No one has the ability to understand what is really reasonable or what is really unreasonable, except for these things that are big guideposts. Here's the regulation. You obviously cannot engage in intentional wrongdoing. You have to care. You have to try to care. You can't engage in gross negligence. And that is an appropriate use of the General Assembly's power to look at this very unique situation and say, this is how the rules of the road should be understood by the courts, and we're going to protect the people who complied with government regulation. I want to thank you very much for hearing me out.
Thank you very much. We'll go now to Michael Halloran.
Good afternoon, Mr. Chairman, members of the House Judiciary Committee. It's great to be with you virtually today. For the record, my name is Mike O'Halloran here on behalf of NFIB Maryland. I do want to appreciate the sponsor for putting forward this very important bill. In fact, it's not very often that NFIB is able to hold up and go on the offense like this. And this is certainly one of the legislative priorities for small businesses. Civil liability from COVID-19 is a real threat to nearly every person, every business, indeed every nonprofit as well. Without passage of HB 508, Maryland small businesses owners face unfounded threats of legal action that could wind up costing them thousands of dollars. Indeed, legal experts have determined that legal fees could add up anywhere between $20,000 to $50,000. But I want to point out, just like the sponsor did, there are two undisputable facts that even opponents of this bill have to agree. Number one, this is not blanket immunity. A claimant who wants to bring a legal suit against a business or nonprofit, they can still do that even with the passage of House Bill 508. The second part is that this bill will expire 180 days after the expiration or rescission of the governor's emergency order. So in other words, God forbid there should be another pandemic in our lifetime or in our children's lifetime, the impacts of HB 508 will not have any impact. So in closing, House Bill 508 still holds bad actors accountable, and we do appreciate the time. And for these reasons, NFIB supports House Bill 508 and asks for a favorable report. Thank you.
Thank you very much. We'll go now to Michael Sanderson.
Thank you, Mr. Chair, committee members. I'm Michael Sanderson with the Maryland Association of Counties. We're also here in support of House Bill 508. I'll just say, for the most part, public sector employers stand in a similar shadow to the private sector counterparts, and I would attach myself to the comments you heard from both the sponsor and the supporters of the bill. We thank them all for working on this. I will say there's one particular respect where local governments and counties in particular are different. We don't face the brink of going out of business. Counties aren't going to go out of business over this, but we also have a circumstance where we can't say no when you dial 911, even if it's an emergency. So we have a condition, we have a requirement to help our residents and to help our citizens, not only including, but especially in times of crisis like this bill is related to. So you've heard the framework of the bill, and I think it's awfully reasonable. The good faith standard is one that we think is okay. And if it turns out we missed a rule or something, then we should face that. But the notion of going to your government as a deep pocket for a possible, let's try and find some settlement value out of this is a genuine worry among local governments. It would just divert resources away from the services we all care about. So support the bill, and we thank you.
Thank you very much. We'll go now to Ellen Valentino for 2 minutes.
Thank you and good afternoon. My name's Ellen Valentino. I'm here today representing the Mid-Atlantic Petroleum Distributors, and that's the state's regional convenience store owners of service stations and petroleum distributors association. And, I think it's important, please know that the issue of lawsuits stemming from COVID is of top of mind for our members and almost the entire small business community. MAPTA members, my members, were classified as essential employees, and we did work daily to comply with executive orders, but it wasn't just executive orders, right? It was PSC orders, it was local orders, it was a tremendous amount of ever-changing local direction, and we made an effort, and to this day we're doing actually I think the best we can. This has been a beyond imaginable event, not just for small business but for all Marylanders and people across the world, and so we hope that you consider this legislation. We think it's an important factor. Maybe it's one ounce, one tiny bit of certainty that you can provide us into this economic event that continues to unfold. So, lawsuits, that's our country was built on, three government checks and balances, but sometimes lawsuits, can seem like they were frivolous. But these lawsuits that are going to be brought as a result are only the result of a pandemic, when a business has given best effort. We hope that you move to put some restrictions in place. Thank you.
Thank you. Benjamin Seidel.
Thank you, Mr. Chairman. And I wish also to thank Delegate Attar for putting such an important bill together. My name is Ben Seidel. I am the owner of Real Hospitality Group. We are based here in Maryland. We operate just over 100 hotels for other owners and having over 3,000 employees. We stayed open for most of our hotels throughout this pandemic, providing services, essential services to healthcare workers, government agencies, and essential travelers throughout, all within CDC guidelines to the best of our ability, also extenuating to local guidelines and local ordinances. We too, like most, are a responsible employer. And during this pandemic, I think I speak for a lot of us entrepreneurs when we say that we care more about our employees and their safety and that of our guests than we do even ourselves. But I want to explain how it works on our side. We're not a big government agency. Obviously, I'm just a small business. Things like this where attorneys advertise, according to the U.S. Chamber of Commerce, $23 million has already been spent in 2020 by plaintiff attorneys that are luring potential clients to be entitled to significant compensation. And once they have those clients lined up, proof or not proof, you get documents like this. This is called a courtesy pre-litigation notice. It's a 19-page lawsuit that says courtesy pre-litigation notice. I'm not sure what I'm supposed to do with that. My attorney says that is not a lawsuit yet, but I have to turn that over to my insurance carrier for fear that if I don't, they would deny the claim later on. I carry a $10,000 deductible per occurrence, which is not unusual for people in our business. So getting 20 or 30 of these letters over the course of 105 hotels could easily throw a company my size into bankruptcy. I just wouldn't be able to afford it. There are companies that are pumping out of the woodwork until this gets resolved, like this one that sent a notice that just simply basically says, we save you time and money by reducing your legal and financial liability when it comes to your COVID liability risk in Maryland. I want to thank you, Delegate Attar, for putting this so important legislation, this bill put forth. And I pray on behalf of the small business people in the state of Maryland, this passes. Thank you very much, Mr. Chairman.
Thank you very much. We'll now take questions for this panel of people in support of the bill. Members who wish to ask questions should click the raise hand button in the participant section, and I will make my way through the list. I'm going to begin with Delegate Moon.
Thank you, Mr. Chair. I just am curious how you would see this playing out in the real world. I'm trying to think of the scenarios here. And so the first one, the very first, I think, constituent call I might have had during the COVID emergency was from someone who worked at a nursing facility, I believe, and early in the pandemic wanted to wear a mask, but the employer prohibited them from doing so because they didn't want to alarm the other patients. And so I guess in the scheme of let's just say, let's just say something happened and that person or someone else contracted COVID. I'm just curious, where you think the line should be drawn on something like this.
I can answer that if you're asking me directly. So
just curious, any of the supporters, like how should we treat a scenario like that?
So I
It
can't
depends.
say.
If I could just jump in, the CDC guidelines back in March were face masks were not important. In fact, could do you more harm. So we practiced that. We followed the CDC guidelines. We followed the guidelines of Larry Hogan, of the different governors that we work with, of the mayors in the towns that we work with. And it has been an all-out effort to stay compliant. So I would say that if we followed CDC guidelines, we shouldn't be sued or even have the opportunity to sue. And especially attorneys that are luring potential clients for the sake of easy settlement dollar. Page 17 of this lawsuit suggests that I called this lawyer to save us both time and money and negotiate a settlement to make this all go away. This is just copy and pasted and just sent out en masse, and it's not going to stop. I'm sorry, Delegate Attar, I stepped on you.
No worries. Delegate Moon, if I can just very quickly say, if after March 5th, this is starting from March 5th, if they contracted COVID and their nursing home, their boss did not follow any of these guidelines, they will probably be found to be grossly negligent and they can be sued. Now, if it wasn't in any statute, in any regulation, and it wasn't a guideline, I can't say how that'll turn out. But if this doesn't protect wrongdoers. So if I'm a pizza shop owner and I say, you know what, these masks are driving me nuts, I don't want you to wear it, I'm negligent, and the employee can still file a lawsuit. This does not prevent anyone from filing a lawsuit. It's just whether or not in the end they will be immune.
Okay, we'll go now to Delegate Bartlett, then Delegates McComas and Shetty. Delegate Bartlett.
Thank you, Mr. Chair. And Mr. Seidel, thank you for your testimony because you actually anticipated some of my questions because my question was whether or not there were many pending cases, and I see that there are many. But does anyone, and this is for anyone, does anyone have any cases that have been decided at this point? That's one question. And then my second question is, I heard someone say good faith standard. So we obviously there has not been a standard of care established yet. And if not, why wouldn't the current negligence law be enough, I guess is my question.
Maybe I can take a swing, particularly at the last part of that. A negligence lawsuit involves someone saying the standard of care is you were to do this and not do that. And we all know as jurors, for instance, we use our wisdom to figure out really what those prescribed actions are, what you can do and what you can't do, and when that caused an injury. And in the situation, because we really had a hard time figuring out, how this thing causes injury and what you're supposed to do that is a level of due care. I mean, is it good enough to wear a mask? Do you have to stay home if you choose to go out and if you take on that risk? There are so many government guidances and regulations put upon that what this bill says is, if you follow those guidances and regulations, then you're not going to be liable. I mean, it's a way of saying that is not negligence at all in this situation, in this very unique situation. You asked about good faith, and what that really means in the situation as stated in the bill is three things. One, you followed the guidance and the regulation. Two, you did so with an intent to be reasonable. You were not grossly negligent, which is to say in reckless disregard for people's health. And the third thing is you didn't intend to hurt anybody by what you did. So the problem that I think this really speaks to is that it's easy to say that there was a lack of due care. It's easy to say, I got sick here, I didn't get sick over there, and it wasn't the other place that I got the invisible droplets that carried this virus. There's just a lot of unknowns, but what we know is that the government has issued guidance, issued regulation, and the General Assembly should say, that is the thing that you should do. If you did it, you're not liable.
So is this bill, Delegate Attar, is it in anticipation more so than anything else? Because my first part of my question was, have there been any judicial decision? Has there been any case law yet? Any cases that have been decided on this issue? And is this in anticipation of cases that are coming? And so essentially you're asking the legislation to do the work that would be done on a case-by-case basis.
So this is what I would say. It's my understanding in Maryland, there has been no adjudication for a case like this. But I also want to point out that I believe about 20 other states have enacted legislation similar to this in anticipation as well. And there are many others that are debating legislation currently that will protect businesses and organizations in their states. Mr. Seidel had brought up that there are complaints, and I've heard from business owners that not necessarily have things been filed yet, but they've heard complaints, and I've had business owners telling me, I had an attorney that I paid to help me figure out what these guidelines are and to do everything. And now I'm concerned that I'm going to have to pay thousands of dollars to a lawyer to defend myself when I did everything right. So this is, yes, in anticipation, but it's also based off of complaints that businesses and organizations have gotten, and they believe this will happen.
And if I have one more quick follow-up. What I'm concerned about is that it should be on a case-by-case basis. That's my problem, because it is a fact. You know, every situation it needs to be heard based on the facts that exist. I think that there are some people who truly can show, look, I did everything that I should have done, and someone still got sick, but I did everything that I was supposed to do. And then there are going to be some people who are going to say, I did everything I was supposed to do, but there were some things I didn't know about, or whatever. And I think that should be heard by the court. What I'm concerned is this blanket liability. If you can help me go through that on how this blanket liability is going to weed out those situations in which, someone, is it going to protect everyone, even those who did not necessarily follow, just by simply saying, look, here's the executive order, I've got it in my hand. This is what the law was at the time. And so I did the best I could.
So no, the answer is that it is going to be a case by case, because anyone can still file a lawsuit. This is not immunity. This is not preventing anyone from filing a lawsuit. So if I believe that my employer, or I went into a store and they did something wrong, I can still file that lawsuit. The question is whether or not the judge will rule in my favor, whether or not what the burden of proof is for the plaintiff and the defense. So that's what it is going to be determined on a case by case basis. It's not saying, no, if the business shows us they did everything right, they don't even have to come to court, they don't have to do anything. Businesses are still going to have to defend, and organizations are still going to have to defend these lawsuits. The hope is that this will probably reduce the amount of lawsuits when people realize the burden is a little bit higher. But if someone feels like they were really wronged and they have proof that their employer was grossly negligent, they can still file the lawsuit, and it will be determined on a case by case basis.
Okay, thank you.
All right, we'll go to Delegate McComas, then Delegate Watson. Delegate McComas.
Thank you, Mr. Chair. This is for either Gardner Duval or Mr. Sanderson. In other words, we have to have this bill because the defense can't be that the COVID virus was an act of God, because I know there are insurance policies that if it's something that just kind of comes out of the blue, it's an act of God and they don't have to pay, or it's an act of war, which you can't control. So I was just kind of wondering, this virus was not predictable, and we don't know that much about it. It's not like it's the flu or measles. So would that play into this at all?
Delegate, there has been quite a bit of activity on the insurance side, mostly for business interruption and not the kind of liability that we're talking about today. There isn't a great deal of certainty, but certainty about how your basic business coverages are going to apply to these kind of liability claims. You correctly identify really what the questions are. Does the policy explicitly exclude it, or will the insurer say this one is just so far off the charts that it falls within those exclusions that you identified, the act of God or force majeure, that sort of thing. I do want to just take on one other brief point. This bill does not affect workers' compensation. If the question is whether someone was hurt on the job and whether their employer is liable, that is a question for workers' compensation and expressly outside the scope of this bill.
All right, Delegate Ron Watson, then Delegate Cox.
Thank you, Mr. Chair. Thank you, Delegate Attar, for bringing this bill. My citizens in the city of Bowie, all my business owners have been waiting for this for some time. My one question is related to potential ambiguity, and maybe you can help me understand. Right now, we're still under emergency via the governor. There's going to come a time, either based on some metrics or economic conditions, he's going to sound the all clear. And I'm thinking about that 180-day period after he does that. What is the standard? You know, if I'm a business owner, what is my standard? Is it, you know, the locals have eased up, but we know that the virus is still out here. Do we still follow CDC guidance? Will it even still be applicable at that point? Because it just seems like there was, you know, local, federal, CDC. What would the standard be once the all clear is sounded?
Thank you, Delegate. So whatever regulation is still in place at that time would be the standard. So if there's only federal regulations, that would be the standard. If there's local, state, and federal regulations, that would be the standard. Now, I don't know what it's going to be like, and I don't think anyone knows what it's going to be like when the governor decides to end this executive order, and we're in those 180 days. But if there are still standards out there, those are the standards that the businesses need to follow. I hope that answers the question, but I don't know the answer as to what it'll be like then.
Yeah, well, I think your answer captured what I was trying to say, because even though the governor had standards, the counties had a lot of flexibility to do what they wanted to do based on their own interpretation or their own metrics they were capturing. But I think your answer still answers the mail, but thank you very much.
Thank you.
Yep.
Delegate Cox and Delegate Griffith.
Thank you, Mr. Chairman and Delegate Attar. It's a great bill. I appreciate you bringing it forward, and to those who are here from the business community. I just wanted to clarify, what about, I think in my reading of the bill that it exempts employment discrimination claims or health-related claims. Is that your reading also?
I believe so, but Mr. Duval, do you know if it does not? I believe it does. That's my understanding as well. Is he still on here?
Yes, I'm sorry, I was reading the bill and not in my mute button. I think that is the correct interpretation. That those aren't really the kind of third-party liability claims that are addressed by the bill at all.
Thank you. That's what I thought. Thanks so much.
Delegate Griffith.
Thank you, Mr. Chairman, and thank you, Delegate, for bringing this forward. And this is for the anybody part of the panel. I think this was addressed some, but I want to just be definitive. For the average small business that may be required to defend against one of these lawsuits, what would you estimate is the total cost all in for them to defend themselves? Just ballparkish.
If you're asking me from the private sector, if I turn it over
Yes.
to my insurance company, I have a $10,000 deductible per occurrence.
What would that impact be on like a small business, like the corner pizza shop who's been struggling to make it through this whole pandemic, who might be teetering on survival?
We're all teetering on survival. It's going to be devastating. The alternatives are some folks, if they have this liability that are maybe seasonal businesses on the Maryland's Eastern Shore or over in Western Maryland would likely decide just to hold off on opening as opposed to open themselves up to liabilities like this. It can wipe a business out. Legal costs are a very expensive part of the business. That second attachment that I showed are companies coming out of the woodwork that are offering their services for a large fee to help me limit my liability and the cost and time that it's going to affiliated with all these inevitable flow of lawsuits that are going to come out of this. I don't mean any disrespect to our professionals in the legal profession, but there's bad players in every industry and in every profession. And these guys have already started with their multi-million-dollar advertising campaigns featuring the buzzwords we all like to hear is that we're all entitled to substantial compensation. What do I have to do to get it? And that's signing a letter with an attorney, and then he throws, in my case here, it's a cut and paste letter, handwritten in blue ink, my name and my address. It's just something that's been spit out to thousands of people, I'm sure. I can't verify that, so I would never be able to go on the record with that, but that's what we're all scared to death of.
I mean,
And
would you anticipate?
those of us who are bad players, you know, a video or a picture of an overcrowded bar or restaurant or something like that. I agree with Delegate Atari. Those folks that are, you know, chasing the almighty dollar while we're all hurting for here need to be held liable for those actions. If somebody got sick or got hurt needlessly at the fault of somebody else, nobody's asking for that. We're asking for to limit the frivolous mounting of just easily signing documents and sending them out via courier mail in the form of a courtesy pre-litigation notice. This is indicative that the frivolity of this whole pandemic is going to be a profit center for some at the cost of businesses that can grossly ill afford it right now.
So you believe, and this is my last question, so you believe if we don't create some kind of protection for these small businesses, just the fact of these businesses defending themselves, even if they win, could be the final blow for some of these small businesses?
In my opinion, sir, it would never get to a trial. These things they rarely do. They go into insurance companies' hands and then they settle. It's so obvious that on page 16 of this, it asked me to call him so I could arrange a settlement. So we put this all to bed before anybody spends a dime. The attorney on the other side of this, I would imagine, takes a standard 40 to 50% of whatever he can recover for his client for minimal labor. I agree with Delegate Attar. I think that it just needs to be a deterrent that says that these businesses do have some level of relief, that if you're going to go after one of these businesses, I think that you should be prepared for the long haul. And that, you know, it's not just going to be easy settlement dollars by putting out a cut and paste letter that's labeled very nicely a courtesy pre-litigation notice.
Thank you.
Thank you.
Delegate, I think that's a second bite of the apple, Delegate McComas, isn't it? Trying not to do that, trying to stay on topic. So I'm sorry about that. Are there further questions? No second bites. All right, seeing none. Thank you all very much. I appreciate hearing from all of you. And now we're going to go to the opposition. There are 9 people testifying in the opposition. Kind of inclined to just hear from everybody and then we'll take questions to the group as a whole because I think that's a little more efficient. So we'll go ahead and hear from Patrice
Thank you.
Wildberger, Emily Malarkey, Mary Koch, Kelly Donahue, Patrick Thronson, George Tolley, Christopher Norman, and Ellen Flynn. We'll give each one of them 2 minutes, then we'll do questions for the group as a whole, and we'll go from there. So if we can go to Patrice Clark for 2 minutes, that would be great.
Good afternoon, Mr. Chairman and members of the committee. My name is Patrice Meredith Clark, and I am a trial lawyer in Pasadena, Maryland, and I'm a member of the Maryland Association for Justice. This bill seeks immunity for all COVID-19 claims, and that's a defined term in the bill. And that means that members of the public who are injured because of contracture of COVID or exposure to COVID, because a business or institution did something that was unreasonably unsafe, cannot recover damages for those injuries. Now, as the bill is currently worded, it has a specific provision for in the bill. I'm sorry. Can you all hear me?
Keep going.
Okay. It has a specific provision for gross negligence or intentional wrongdoing. It's my understanding that in the Senate hearing, Delegate Attar talked about a potential for a good faith provision. What I would like to talk about is that such an amendment to add a good faith provision really doesn't do anything because it would require an injured person to prove that a defendant was not acting in good faith. And what does that mean? It means you would have to prove bad faith. Bad faith is the opposite of good faith. Maryland's Court of Appeals has said that bad faith is not simply bad judgment or negligence, but it implies a dishonest purpose or some moral obliquity and a conscious doing of wrong. So in order to maintain a claim, the injured person would have to prove that the defendant intended harm. That is not a negligence claim. That is an intentional tort, which is a totally separate and distinct cause of action under Maryland law. The proponents of this bill say that the goal is to protect small businesses from spending bunches of money in attorney's fees to defend against lawsuits. Preliminarily, I'm not aware of any negligence lawsuits that have been filed in Maryland that would qualify as a COVID-19 claim. But I would argue that this bill would have the opposite effect. Indeed, in response to Delegate Bartlett's question about dealing with these cases on a case-by-case basis, Delegate Attar said, anyone can still file a lawsuit. And she's right. And then the businesses will be forced to litigate whether the businesses acted in compliance with all of the regulations that are cited in the bill. And then they'll have to litigate whether the business is engaged in, quote, an isolated minor deviation from strict compliance. The point is, in practicality, this bill will have the opposite effect of decreasing litigation costs. For these reasons, and for the reasons that will be articulated by the other opponents of this bill, I would urge an unfavorable report on House Bill 508. Thank you very much.
Thank you. David Wildberger. You're on mute.
Wasting my time on mute. Thank you, Mr. Chairman, Ms. Vice Chair, and committee members. A couple minutes ago, I heard one of the proponents, Gardner Duvall, say that there are no rules of the road for this. Well, respectfully, there are. It's called the Maryland Constitution. And the problem with this bill is that it retroactively impairs an accrued cause of action, which under 180 years of Maryland jurisprudence is a vested right. Minutes ago, I heard one of the proponents, Gardner.
Sorry, Mr. Norman, you're not, there we go. Mr. Wildberger, go ahead. We'll give you a few more seconds.
Okay, I appreciate that. There was mention of the Dua case. The Dua case held that there is a vested right in an accrued cause of action, and the Maryland Constitution precludes the retroactive impairment of such right. And that's Articles 19 and 24 of the Maryland Constitution, 180 years of jurisprudence. So let's get some definitions. When does a cause of action accrue? A cause of action accrues when the harm occurs or when the plaintiff knows of the harm. That means the cause of action in these cases accrue between March 5 and today. Once a cause of action accrues, it becomes a vested right. Negligence is a discrete cause of action. It has its own elements. What this bill does is it impairs, frankly, I'd argue abolishes, the negligence cause of action, which is a vested right. It is an accrued cause of action, and it substitutes something much different. It substitutes an intentional tort cause of action, which has different proof. It has an enormously higher level of proof, and under 180 years of jurisprudence, it is unconstitutional. You can't take people's rights away retroactively. And that's exactly what this bill does. Now, the proponents may say, well, you know, this bill doesn't abrogate or kill a cause of action. Well, it doesn't have to. There's a case called Prince George's County versus Longton that says a vested right is not any less impaired in the eyes of the law merely because the impairment is partial. The Constitution, as Dua makes clear, the standard for determining whether retroactive litigation violates the Constitution is whether it abrogates or significantly impairs vested rights. There's no way you can say that this bill doesn't impair vested rights. Now, I'm a small businessman.
Mr. Wildberger, if you'd wrap up, please.
Sure. I'm a small businessman. I have a small law firm in Anne Arundel County, and I understand these issues. I understand the concerns. But we can't throw out the Constitution. The Constitution either applies to everybody or it doesn't apply to anybody. Thank you. I urge you to vote this unfavorably. Thank you so much.
We're going now to Emily Malarkey.
Good afternoon, Mr. Chair and members of the committee. I'd like to just piggyback off of something that Mr. Wildberger just said. We, and when I speak about we, I'm talking about the members of the Maryland Association for Justice and the trial lawyers, are small business owners ourselves. We are acutely aware of the economic impact that this pandemic has had. We are all suffering from it the way that all small business owners are suffering from it as well. But what I want to focus on for my time is the questions that were asked earlier about the practicality. I think we heard that this bill is designed to prevent opportunistic COVID lawsuits that are real threats. And I'd just like to pose the question, what real threat are we talking about? I know myself as a small business owner, we could not take a case of someone who is interested in bringing it because of legal doctrines that already apply. We have in Maryland doctrines of assumption of the risk and contributory negligence. So if I had a person come into my office and say, I'd like to bring a lawsuit against the bar because I got COVID, I would say, no, thank you. You went into a full bar 4 people deep when you knew the risks of engaging in that activity. You don't have a case. Similarly, I'm sure we're all familiar with the waivers that we and our family members have been signing since March. My children participated in sports. Every single time my son goes to soccer practice, I have to sign a waiver. I went to a hotel in the fall for a long weekend with my family. I had to sign a waiver. We went to the pool this summer before we could go. We had to sign a waiver. Those are not cases that we can take and handle in court. So I really do not believe that there is, in fact, a true, very real threat of opportunistic lawsuits given the state of the law as it already exists because of the standards that apply. And I would urge an unfavorable report.
Thank you very much. We will go now to Mary Koch.
Sorry about that. I'm still not adept with the computer. I want to thank all of you for sitting and listening to us today. I am opposed to this bill. And I will tell you that what strikes me immediately when I look at a bill like this is that although many can look at this and say it is a noble effort to attempt to protect our small businesses, which it is, this is not a bill that is directed only at small businesses. There is nothing in this bill that tailors it to a certain size business, a certain number of employees, but rather this would protect corporate defendants just as much as it would affect the small businesses that are in our communities. That's the first thing. The second thing I would say is, and I think I'm piggybacking on what my colleagues have said, is that in many ways, this is a solution looking for a problem. And I say that because our laws are written in such a way to be fluid. And there are already allowances in the law that allow for the defenses that are already being brought up in this immunity. For example, negligence is always determined by the reasonableness standard, whether or not someone acted reasonably. And everyone will be putting forth during this period of COVID how the COVID pandemic affected their ability to be reasonable. And I would say that it will move the needle on how reasonableness is defined as relates to the COVID time period. So our law already has the ability to adapt to all situations, and we don't need to create more legislation that takes the ability of people to bring valid lawsuits into the courthouse and ignore those things that are already the safety valves for all of our businesses. The other thing I would say is I was struck by Mr. Seidel's comment, and I think I'm dovetailing a little bit on my colleague's comment as well, that he would have to pay, he would have to contact his insurance company. This is not, the fact that he would have to contact his insurance company and defend a claim is in no way resolved by this litigation. All of those things are still going to happen. It's not going to change that fact. But I will say this for sure. I will say that, as my colleague, Ms. Malarkey, said, we look very carefully at these cases, and none of us is interested in taking a case in which an individual was contributorily negligent or who assumed the risk of a potential injury. Thank you for your time, and I hope that you report unfavorably.
Thank you. Kelly Donahue, please.
Good afternoon. Thank you, Mr. Chairman, ladies and gentlemen of the committee. My name is Kelly Donahue. I am a member of Maryland Association for Justice and a trial lawyer. And I am here today to ask you for an unfavorable report on House Bill 508. I'm going to keep it short because I think my colleagues have very artfully covered most of the points. But one of the things I want to start out with is I wholeheartedly agree this bill is a can of worms waiting to happen. When you read section C at lines 11 through 22, lines 11 through 17, carves out an immunity where a business has acted in compliance with rules, regulations, executive orders, agency orders. I would proffer to you that if businesses have done those things, they are not negligent. There is no lawsuit to bring. So there would be no reason to impose an immunity because they have no liability. Sections 18 through lines 18 through 22 that includes language, an isolated minor deviation from strict compliance. That language is confusing. It's incoherent and has no basis or legal explanation in Maryland law to tell anybody what that means. This kind of language, all this does is stimulate litigation over a statute that is currently unnecessary. We have been monitoring the extent of litigation as it relates to COVID in the state of Maryland, and there is nearly none. The floodgates are not opening. As Ms. Malarkey and Ms. Cook pointed out, as trial lawyers, the overwhelming majority of us handle negligence lawsuits on a contingency basis. It is our money and our time that we front to litigate these cases. It does us no good to bring lawsuits that are not meritorious, either because there was no negligent act, or because the plaintiff assumed the risk of their injuries, or because the plaintiff was contributorily negligent. So right now, there is no crisis. And even if somebody wants to send a lawsuit, those are my COVID office mates. Even my life has changed. But the point is even if somebody wanted to bring a lawsuit, as unmeritorious as I think it may be, and I'm telling you, I think it is, the fact of Mr. Seidel paying $10,000 to his insurance company and then to litigate whether these immunities apply isn't going to change. So I think this is an unnecessary overregulation of government involving themselves that just is not needed at this point in time. And I'd ask for an unfavorable report. Thank you.
Thank you very much, Patrick.
My dog thanks you too.
Patrick Thronson.
Good afternoon, Mr. Chairman, members of the committee. My name is Patrick Thronson, appearing on behalf of MHA. I wanted to emphasize to members of the committee, this may be old news to many, how expensive and risky these cases are to bring. I represent primarily victims of medical malpractice and also personal injury. These cases can range in out-of-pocket expense anywhere from $50,000 to $300,000 or more. We do not take these claims on lightly. We take seriously our obligation as attorneys and officers of the court to only bring claims that we believe have merit for injuries that we believe are real. And it's a serious investment of expense that is entirely borne by us. If we lose, if our client loses at trial, we get nothing and we're out that money. There's no way to recover it. This is not a market. We're not in the business of frivolous litigation, and particularly in an area that's fraught with problems of proof so much as this one, in terms of proving the origin of a COVID-19 infection. I submit that the unintended consequences of this bill are going to be much greater than its purported benefits. As Ms. Donahue was remarking, there are a lot of ambiguities with this bill. The assumption appears to be that the rules, regulations, executive orders, and agency orders would all be consistent. And also it assumes that those which are out of date are denied legal effect. Denied legal effect typically refers to the action of a court, or at least that language is ambiguous. And so this legislation will be a full employment act for the lawyers engaged in litigating these claims. So for those reasons and the others articulated by the opposing panel, I urge an unfavorable report. Thank you.
Thank you very much. George Tolley.
Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the Judiciary Committee. I'm George Tolley. I'm Legislative Chair for the Maryland Association for Justice. You might be wondering if these claims are so difficult to bring and so unlikely to be brought, why there is a small army of trial lawyers in opposition to this bill. And the answer to that is not because we are champing at the bit to file these claims. All right, 350,000 plus Marylanders have been sick with COVID so far. There is a grand total, according to the best tracker of COVID-related claims there is, a grand total of 2 transmission of COVID or fear of transmission of COVID cases filed in Maryland to date, one of which is an employment action filed against the University of Maryland in federal court, and one of which is a wrongful death action filed in Maryland Circuit Court in Baltimore. We've identified those, and we'll talk about those maybe with the next bill too. There isn't an avalanche of lawsuits. There isn't it's fear-mongering to say that the civil justice system should be turned upside down to protect businesses because of a fear of opportunistic lawsuits. And really that's what we object to, is the idea that you're portraying plaintiffs' lawyers like us as these villains in this opera. We are not. We are responsible small business owners, and we take very seriously the business of protecting the civil justice system against unnecessary, vague, unconstitutional, and unfair immunities. The last point I want to make is, if we want to reopen our economy efficiently and effectively, the last message we should send to the public is that businesses have immunity if they cut corners and don't do everything they need to do. Businesses will say they're complying with all of these regulations and rules, but the rules and regulations aren't spelled out in the statute, and it's vague to understand whether they did it or not. And the statute also includes an exception that if you don't follow all the rules, you still have immunity.
Mr. Tolley.
So, with that, I urge an unfavorable report. Thank you for your time.
Thank you very much. Mr. Norman, for 2 minutes, please. Mr. Norman, you're on mute.
Pardon me. Thank you, Mr. Chairman and members of the committee. My name is Chris Norman. My family has owned for 3 generations a small tire shop on Main Street in Bel Air. I understand the concerns of the business community and I sympathize with them. However, to all those members on this call, in this committee, who feel the pressure from businesses in your district to do something to protect them, you should know that passing this bill is an empty promise. It will ultimately do nothing to protect them. It does not stop the need for them to defend against lawsuits. And more importantly, the law is unconstitutional. So when it's passed, it will be struck down. And then you'll be leaving your constituent businesses with no protection at all. As a Republican, and more importantly, as a Marylander and a citizen of the country, the Maryland Declaration of Rights, the Maryland Constitution, and the Constitution of the United States means something to me. Right here in the city of Annapolis in 1867, a constitutional convention was assembled and the Maryland Constitution in its current iteration was adopted. That Constitution includes very strong protections in Articles 19 and 24 that say that an individual cannot be deprived of their life, their liberty, or their property. The Fifth Amendment to the U.S. Constitution provides similar protections. In addition to prohibitions against double jeopardy and the rights against self-incrimination, the right of property is also contained within the Fifth Amendment. It's a right that we should not be abrogating. The expressly stated purpose of this law is to go back in time and take away the rights of an individual who was injured by the negligence of a business during the pandemic. And doing so would be in direct violation of the Maryland and the United States Constitutions and their prohibitions against takings, the Takings Clause. This bill, again, is in direct violation of individual rights, constitutional rights, and I urge you to respect the Constitution and report it unfavorably. Thank you.
Thank you very much. Questions now for the panel, the big panel. Delegate Williams to begin, then Delegate Cardin.
Yes, thank you, Mr. Chairman. Just really quickly, I wanted to, I think it was Mr. Weidelberger, get the citation of the case that he was mentioning, the Prince George's County. I don't know if he has the citation handy by chance.
I do, Delegate. There's actually 2 cases I'd like to give the citation to. One is Prince George's County versus Longton, Longtin, 419 Maryland 450. It's in 2011 case. Now, in that case, I'll just sort briefly, if you want to know, there was a fellow who was wrongly incarcerated for many, many years. He came out, he sued the state, he won. The state said, even though you went to jail before we had this cap on your recovery under the Local Tort Claims Act, we're going to apply that retroactively. The Court of Appeals said you can't do that. That would have not abrogated, eliminated his recovery, but it sure would have lessened it. And what they said was a vested right is no less impaired in the eyes of the law merely because the impairment is partial. Now, the other case I'd commend to you is DUA, D-U-A, versus Comcast, C-O-M-C-A-S-T, 370 Maryland 604. That's from 2002. The DUA case, the Court of Appeals looked at 180 years of jurisprudence. They looked at over 40 Maryland cases and about a dozen out of state cases. And they concluded, they reaffirmed what has always been the law of Maryland, that once a cause of action vests, you can't retroactively take it away. You can prospectively do anything you want, but you cannot retroactively take away an accrued cause of action because that is considered a vested right under Articles 19 and 24 of the Maryland Constitution.
Thank you. And I have one other question, Mr. Chairman, since we can't take multiple bites at the apple. The other question I had, I think it was Ms. Meredith Clark, you had mentioned increased litigation costs. How would that also translate in terms of insurance costs? I don't know if you would know that, but I mean, my gut is that that would probably also increase insurance costs from a general liability insurance coverage and things like that. I don't know if you have any insight or if anyone on the panel has any insight with regards to that.
Thank you for that question. I'm not sure if you're talking about insurance premiums in terms of moving forward, that this this particular legislation would have a positive impact. It could have a potential for a negative impact. No matter what, I think the point that many of us are trying to make is that the legislation as it's written is extremely unclear. I think Ms. Donahue did a good job citing to the portion of the bill that would lead to additional litigation. And I think it might have been Mr. Tully who also pointed out the provision that says an isolated minor deviation from strict compliance with the federal, state, and local statutes, rules, regulations, executive orders, and agency orders related to COVID-19 that is unrelated to the plaintiff's injuries does not deny a person the immunity provided under this section. Well, what does that mean? And so whether insurance companies would increase premiums or not, I don't know. What I do know is that this will lead to additional litigation, which insurance companies will likely be responsible for at least covering a portion of, which in turn could lead to increased premiums. But no matter what, it's not going to save businesses money either on the front end of paying their deductibles, and it's not going to save them money in defense costs. And I don't know if anybody else has anything to add to that.
Mr. Waldberger, I see your hand.
Mr. Waldberger, now you're muted.
David, you're muted.
I'm an old guy. I have a hard time with technology. The point that I would make is that the language of this bill is so unclear. A businessman has to comply with all federal, state, local statutes, rules, regulations, executive orders, and agency orders related to COVID-19. I have no idea what that universe is, and I don't think anybody else does. And I don't know how, as a small businessman, I could be sure that I'm complying with all of those. Local statutes, rules, regulations, executive orders, and agency orders. Now, the point about litigation is this is an issue that is going to be litigated endlessly when these cases are brought. I don't think many of these cases are going to be brought because it's going to be really hard, except in specific instances, to prove that somebody got COVID from a particular pizza shop or whatever, because people are everywhere and it is everywhere. But the issue is, and even the sponsor in the Senate admitted, these rules, regulations, executive orders, and agency orders are sometimes in conflict. And if they are, how does a business person follow them? And how does a litigant go about proving that they have or they have not? Well, in this case, with this bill, you have to prove that they intended not to follow them, because this throws the negligence cause of action out the window and substitutes an intent cause of action. All of this is going to lead to much, much, much additional litigation costs in the cases that are actually brought. Thank you.
Thank you. Those are all my questions, Mr. Chairman.
Great, thank you. Delegate Cardin.
Thank you, Mr. Chair, and thank you all for your very compelling testimony. I appreciate it. Apologize for the sound in the background, my daughter and doing her school. This is really for Mr. Wildberger, I guess, or Mr. Tully, but you had talked about how the unconstitutionality of it being retroactive, if it was prospective, from the day that we passed the legislation, that it went into, let's say it was an emergency bill and it went into effect from that day forward so that people had knowledge, would that change your opinions? And then the second question is, I guess, for Mr. Thronson, you talked about how you handle cases that oftentimes are $50,000, will cost you, your firm, up to $50,000 to deal with the cost. What about all those other attorneys that maybe aren't members of the Maryland Association of Justice who are taking cases, negligence cases, and expecting to spend $500 or $1,000 or $2,000, and they could be, and they don't necessarily don't hold themselves to the same standards that you do? Those are my two questions. Thank you.
Delegate Cardin, thank you for those questions. As far as if it was prospective only, then there would be no constitutional impediment, no constitutional problem, but all the other reasons it might be bad public policy still would pertain. And if I may just answer the question for Patrick in the interest of time, there is no, I think the point of the testimony from the proponents was that what Mr. Siegel certainly wants is not to be sued at all, so that he doesn't incur his $10,000 deductible. If there is somebody who's allowed to file suits or does file suits because they have low standards, or they're just a lawyer who is not doing what they're supposed to do, that vexatiousness is not addressed by this lawsuit. As the sponsor told you, this legislation doesn't prevent lawsuits. So Mr. Siegel's out his $10,000 deductible in every case, even with this bill, even prospectively. So the bill doesn't quite do what they want it to do. And it would have to be quite different in order to do that. And it would have to be even more draconian and take away even more people's rights in order to prevent even the filing of the lawsuit in the first place.
Okay. I don't see further questions for this panel. And so with that, that concludes the testimony for House Bill 508. We certainly thank everyone for speaking with us this afternoon on that bill. We're now going to go to our third and final bill of the day, and this is House Bill 25, Delegate Cullison. We have several witnesses lined up for this legislation. 1, 2, 3, 5, 6, 7, 8, 9, 10. There are 10 in favor, 1 favorable with amendments, and then I believe the same 9 in opposition. So what we're going to do is we will break these into panels because the first group is a little too big to do all in one chunk. So we're going to go with Delegate Cullison, who will speak for 3 minutes. Then Brian Frazee, Sue Kinter, Van Coots, and Stephen Evans. They will be the next 4, and then we'll remaining witnesses in favor, and then we'll break up the second panel, or the opposition into 2 panels, I should say. All right, so with that, Delegate Cullison, where are you? Are there?
Thank you,
And
Mr.
we will
Chair.
start you. Go ahead.
Thank you. And good afternoon, Chairman Clippinger, Vice Chair Atterbury, and members of the committee for giving me the opportunity to present HB 25 to you today. It's really my job to set the context for the bill. I'm going to let the experts explain it. And the experts are Brian Frazee, who's the Vice President of Government Affairs for the Maryland Hospital Association. He'll walk through the bill. Dr. Van Coots is the CEO of Holy Cross Health, who will speak to the challenges of running a hospital that was one of the hardest hit by COVID. You're going to then hear from Dr. Steve Evans, who serves on the governor's coronavirus recovery team and is the Chief Medical Officer of MedStar Health. He's going to talk about the frontline provider perspective. And Sue Kenter from the University of Maryland Medical System is going to talk about the legal threats hospitals are anticipating. The original statute, which is subsection 14-3A of 06 of the Public Safety Act, was passed in 2002 in anticipation of a possible bioterrorism attack. But at that time, we couldn't have really known what the very real impact on all the members of the healthcare team would be in a catastrophic health emergency. For many of us, the professional impact of the virus has just been an inconvenience, and our exposure to the virus is limited by the choices we make. But the experience of all of those who work in the healthcare systems has been extremely different, from the hospital administrator to the person cleaning the facilities, doing their work under extreme conditions, and all the while being exposed to the most contagious and deadly virus this nation has experienced in over a century. When the original legislation could not have imagined the full impact of a public health emergency. They didn't think about the need for personal protective equipment, impaired supply chains, or how the sheer volume of people who would be affected would stretch the capacity of facilities to the absolute limit. There were often changing, confusing, and sometimes conflicting, I heard this just a few minutes ago, governmental guidelines and directives. They didn't think about the resources, both human and material, needed to manage an incredibly virulent contagion. The contagion that put every member of the healthcare team at great risk every time they went to work. I'm a firm believer in professional accountability. There have to be consequences for bad actors, but accountability has to be fair. It has to be based on the good faith efforts of the worker with consideration of the factors that may have affected the ability to do the work. Through this pandemic, we've been thanking our healthcare workers with daily applause, blue lights, church bells, you name it. They deserve every bit of this and more. But I think the best way we can show our appreciation is to demonstrate that we understand the challenges that they uniquely face during a catastrophic health emergency, and that when they are working in good faith to do their jobs, we will protect them. 28 states and DC have already done this. Our folks deserve it as well. Thank you for your consideration of HB 25. I'm open to proposed amendments. I look forward to working together towards a favorable report. And I'll turn it over to Mr. Frazee.
Mr. Frazee, 2 minutes.
Great. Good afternoon, Mr. Chairman and members of the committee, including the folks that are joining us from the Health and Government Operations Committee. For the record, my name is Brian Frazee, and I'm here on behalf of the Maryland Hospital Association in strong support of House Bill 25. Included in our written testimony is a letter signed by every Maryland hospital CEO highlighting the critical importance of this issue, which is the hospital field's top legislative priority. And we want to thank Delegate Cullison for her leadership and sponsorship of this bill. At the same time that Maryland's healthcare facilities and providers are taking on the challenges that you heard from the delegate, they are also confronting a real concern around individual and organizational liability. This concern is driven by advertisements from plaintiffs' attorneys on how to bring COVID-related suits, and we have included a sampling of those efforts in our packet. House Bill 25 updates existing law that provides liability protections to healthcare facilities and providers during a state-declared catastrophic health emergency. Our bill seeks to update that current law in 3 ways. Number 1, expanding the definition of a healthcare provider to include the frontline healthcare team members that have been integral in our response to this crisis. Let me note that these agents, contractors, and employees must be involved in the provision of healthcare services. Number 2, acknowledging the impact that the pandemic has had on all aspects of healthcare delivery by protecting providers that care for patients, including those without COVID, in good faith. And number 3, recognizing that the healthcare system will be dealing with the lingering impacts of the pandemic by extending the protections 180 days after the governor lifts the emergency. I want to emphasize that this legislation does not provide broader blanket immunity. Rather, it preserves the existing good faith standard and updates how it is applied to account for the unique nature of a public health emergency like COVID-19. So in conclusion, and on behalf of Maryland's hospitals and their nearly 120,000 employees, we urge the General Assembly to take action this session to update these protections to those who have been working tirelessly to care for Maryland. We look forward to a productive dialogue on the issue, and we appreciate the committee's consideration and urge a favorable report on House Bill 25. Thank you,
Thank you. Thank you. Sue Kinter, please, 2 minutes.
Thank you, Mr. Chairman and committee members. I am Sue Kinter and I am testifying in support of House Bill 25. I would like to address what I believe you will be hearing from the opposition to this bill. You will be hearing from those opposed to this bill that the bill seeks a blanket immunity for absolutely everything and that the bill is taking away an injured party's day in court. This characterization is both disingenuous and inflammatory. This bill only seeks to clarify and affirm the immunities currently available to those responding to a catastrophic health emergency. It is necessary in light of Secretary Neal's unilateral attempt to remove the protection of this legislature previously conferred to our healthcare heroes in the Maryland Public Safety and Health General articles. This immunity is not blanket. It is not a free pass. It will apply only when a provider has been deemed to act in good faith, the standard most applicable to those responding to conditions that are unprecedented and unpredictable, such as this. This immunity does not take away a person's day in court. Any party alleging injury can still file their lawsuit. The defendant will respond with the affirmative defense of immunity, one of 20 affirmative defenses available to defendants in Maryland. A judge will then decide if this defense is applicable. If it is not, the case will go forward without delay. This bill is necessary to affirm that providers taking care of both COVID positive and non-COVID patients will be equally protected when such care has been impacted by the catastrophic health emergency. The legislature in 2002 understood that in a catastrophic health emergency, care to all patients would be affected, not just care to a specific group of patients. Those opposed to this bill would have you believe that it is reasonable and acceptable to deny immunity to a physician's decision-making on a non-COVID patient during this pandemic while granting immunity for that similar decision-making on a COVID positive patient. That was not the intent of the Maryland Public Safety or Healthcare article. Because this bill simply clarifies and affirms the protections available to providers since 2002, it is not taking away any vested right of a patient, and as such, the retroactive provision in this bill is not unconstitutional. I urge you to return a favorable report on House Bill 25, and thank you for your time.
Thank you. Stephen Evans. I think I got the order screwed up. I apologize, but Stephen Evans.
Thank you, Mr. Chairman, and again, thank you to members of the House for the privilege of testifying today. Let me give you 3 specific examples that have been outlined, specific related to this clinical significance in these provisions. The first was related to the definition of a healthcare provider. During this crisis, it was an all hands on deck approach. As you saw and you felt it within the state of Maryland, we surged our ICUs to 2 to 3 times their normal capacity. How do we staff that? Senior medical students, senior nursing students were used to extend our nurses and physicians. Respiratory therapists had to extend their capacity to manage ventilators. You read about it, you heard about it, but we felt it every single day in our hospitals in managing the largest healthcare crisis of our lifetime. We would ask truly that you reconsider extending the definition of a healthcare provider. We use contractors, other individuals that went beyond the normal scope of a routine day by day in a hospital in the setting of this crisis to manage the volume and the complexity of these patients. Secondly, recognize the disruption not just to COVID patients, but to all non-COVID patients. Governor Hogan did the right thing, just like everyone else in the rest of the country, in suspending all elective and non-emergent or urgent surgery and hospital visits and ambulatory visits. It was the right thing to do. But the outcome of that is a delay in care for many of those patients that was beyond our control. It was difficult. You read about it in the papers as well. Patients who delayed care, delayed their back surgery, delayed their hip surgery. There was a delay in cancer surgery. And at the time, in this crisis of an all hands on deck, we did the best of our abilities to manage the COVID crisis as our hospitals and our ICUs were being overrun. The third and equally important is to extend the protection for 180 days after the catastrophic health emergency legislation. We won't turn the light off on this one. COVID will be around forever, but we do need at least 6 months to try to get our hospitals back onto a normal path, into a normal, clear message around how we get back to normal. COVID patients will still be in our hospitals, we'll still be caring for them, but to simply say that we're no longer going to have coverage because the legislation.
Dr. Evans.
And with that, Mr. Chairman, I thank you.
Thank you very much. Dr. Coots.
Well, Mr. Chairman and members of the committee, whether you're a COVID patient or a non-COVID patient, your care has been impacted by COVID-19. It has been a devastating impact on our frontline healthcare workers, both physically and mentally, as they face this pandemic with compassion and determination. For nearly a year, Holy Cross Health has been at the forefront of the pandemic in Maryland, diagnosing the first COVID-19 patient in the state on March the 4th, and then becoming the dominant provider for critically ill COVID patients in the first wave of the pandemic. For these past 11 months, we've cared for more than 2,800 COVID inpatients and 2,500 outpatients, many of whom were from minority and vulnerable populations. From the start of this crisis, Maryland hospitals have met the challenges. First, the unpredictable supply chain and the shortages of PPE and testing reagents. Then the initial lack of effective medications and having to adapt to evolving clinical guidelines as we learn more and more about the disease. We expanded our facilities, tripling ICU capacity and doubling the numbers of ventilators. We complied with state and federal requirements, suspending elective surgeries, and in some cases resulting in deterioration in the patient's care over time. And now we're scaling up to provide community vaccinations, all the while still caring for critically ill patients and striving to soothe anxious families and sadly far too many who are grieving for the dead. We know that the current Maryland law provides liability protections for some, but not others during a declared health emergency. Additionally, the coverage does need to be expanded to a minimum of 180 days following the period of the emergency order, as many of us will still be caring for COVID patients, with some historically staying for as long as 139 days. This act would simply update the liability protections for those who've been actively fighting on the front line of this pandemic and allow them to make good faith and necessary decisions without fear of personal liability. I'll end where I began. Whether you're a COVID patient or a non-COVID patient, COVID-19 has impacted your care. Thank you.
Thank you very much. We're now going to go to questions from the committee. So far, there are 3. Delegate Arakan to begin, then Delegates Cardin and Moon.
Thank you very much, Mr. Chairman. Thank you very much. I'm lucky to see Delegate Cullison twice in one day. That's a nice gift for me today. So I just want to make sure I understand this clearly. So we do have a good faith standard already, right? But because of the sort of unique circumstances around this, there's a feeling that that will not currently protect essentially the non-COVID related issues that we've had. So the doctor that wasn't able to see his patients for cancer treatment, that kind of stuff. And so those are the people or the situations that we're trying to get at. And also, if you're not a doctor, there's other, I guess, ancillary jobs that are not currently covered by our already existing good faith standard. I guess I'm just trying to understand exactly who we're trying to capture. Like if my child broke their leg and they received substandard care because people were moved off of that wing to go and work on the COVID wing, would I no longer have, a case to bring in that situation? That's what I'm trying to understand. Thank you.
I think Ms. Kenter, would you be able to respond to that?
Sure, I would be happy to. One of the individuals or type of individuals not covered that was previously referred to in the testimony are students. So students are currently not covered under the health occupational article. We are utilizing students enormously in our vaccine initiatives, but they're also being used in a healthcare capacity within the hospitals, particularly when our surges increase. Other kind of behind the scene team members that a lot of patients really aren't even aware that they are there are individuals called our supply chain partners. And they're the individuals who are responsible for ensuring that we have all of the PPE we need, all of the ventilators we need, all of the IV pumps we need, all of those type of things. So as an example, a non-COVID patient who may be impacted by COVID would be a patient who, one of the most common examples and one that probably concerns us the most are patients who have undergone or whose procedures have been delayed. They don't have COVID, so they weren't delayed because of a COVID diagnosis. They were delayed because either the way our staffing goes, our surge goes, we have too many patients coming in, we don't have enough ICU beds, so we're going to ratchet back our elective procedures. We are doing that now. That is always in the mix. And that particular patient, a physician has to make a decision as to whether or not that patient's procedure would be non-urgent. And if that physician decides that that patient's procedure is non-urgent, and that procedure is delayed, in theory, the patient could come back and allege a worsening condition, disability, or death. For that non-COVID patient, COVID absolutely has impacted their care because COVID was the reason, the hospitalizations, why their procedure was delayed. We could have a lack of equipment. So what happened very early on in the COVID pandemic for our hospital was one of our life-saving machines. We were at capacity with use for this life-saving machine. We didn't have any more. That was the result of COVID. But a non-COVID patient could very easily have required that piece of machinery. And if we did not have it to provide to that patient because our supply chain didn't manage the supply effectively, that would be the allegation, they would be exposed to a lawsuit.
Okay, yeah, I hear you on those issues. I'm wondering how sort of under the current good faith standard, being unable to access machinery versus a doctor who made a bad choice about what was serious enough to be emergent and what was not serious enough. Do those victims not deserve to have their day in court in that situation when a doctor made what is essentially a bad call? Delaying a cancer treatment that leads to somebody's furthering of illness or death, that I think most people would think is a bad call that should not have been made, even under COVID circumstances.
Well, I think that's what we fear the most, right? Because the lay juror would think exactly that, not knowing really all of the pressures and all of the conflicting, what am I trying to say? All the different priorities that we're working under, right? So we don't know how many other patients he had to make.
Right. I hear you. I hear you. The thing is, that's what you would say in court. You would say all this stuff to the lay juror, wouldn't you? You would say, lay people, here's how it actually works behind the scenes. And they would sort of get the idea, you know what I mean? The idea would be you would want the victims to have an opportunity to hear what happened. Why was this decision made? I mean, it's going to be very inconvenient, I think, for the hospitals to some extent. I don't know how many of these cases you've already had filed. Do you have that? Has there been cases already filed?
Not yet, but what I would say is I don't think a reasonable juror could understand the pressures and the tensions affecting a particular healthcare provider in that particular instance in a 100-year pandemic. I think that's what we struggle with. And that's why we need a different standard from good faith, because no one can recreate. I mean, when we look at our tracker boards, the number of ICU beds available, the number of nurses available, the number of physicians available, and to have a expert witness, which would be required, the plaintiffs would have to bring an expert witness in, and that expert witness would essentially be permitted to opine as to exactly what, and I'm going to use this, it's a dramatic term, but you heard the term all hands on deck. What incredible pressures and competing priorities this particular healthcare provider was at that time, And
I hear you. Yeah, yeah. I hear you. I think that maybe we're underestimating jurors since they've all lived through COVID. But I appreciate the responses. Thank you.
And I think I want to make clear. The defense available to us is good faith. It is not a free pass. The plaintiffs have the ability to prove that this particular physician did not act in good faith. So this is not a blanket immunity under any circumstances. And if the physician or if the plaintiff does prove that the physician did not act in good faith, that case goes through the entire process of litigation.
Mr. Chairman, can I just say two things to that point, please?
Briefly, yes.
Thank you. I appreciate it. So just two things to add to what Ms. Kinter said, Delegate. Number one, I want to make sure that it was clear that this issue of the delayed care because of the governor's order to stop elective and non-urgent procedures is significant for us. But it's significant because the Maryland Department of Health had a follow-up directive to that order saying that non-COVID care was not covered under the existing immunity provided to us in law. And so that is really where the sticking point is for us in terms of that specific example with delayed care. And I also want to make sure that it's clear that we're not taking away someone's day in court here. You heard Ms. Kinter say anyone can still file a lawsuit under this bill. They can under the existing protections we have now, and we are certainly not trying to take that away from folks. So if something bad did happen or there was any question, someone would still have that ability to go to court and demonstrate their case as to why the provider in question or the hospital did not act in good faith, but we are not seeking to take that away through this legislation.
Right. I'm going to go now to Delegate Cardin, then Moon and McComas. Delegate Cardin.
Thank you, Mr. Chair. Thank you all for your very compelling and passionate testimony. And thank you, Delegate Cullison, for bringing this bill. First, my first question is to Ms. Kinter. Thank you again for testifying. The Maryland Association of Justice obviously is opposed to this, and they've put in opposition to it. In written testimony, they talked about an amendment that they asked you guys to consider, and that apparently, I would assume, that was rejected. Can you discuss that? I'm just going to give all three questions, and then you guys can take them. To Dr. Evans, thank you again for the very comprehensive testimony. It helped me understand this a lot better. There was discussion about harming patients' rights in the previous bill. In this bill, MAJ is talking about that. Can you maybe speak to whether your perspective on that? And finally, to Mr. Frazee, the Attorney General has written opposition to this. Can you discuss what your response is to that? Because obviously that's going to be important and compelling to our committee. Thank you.
So I'll begin. They did. The Association of Justice did offer an amendment, and their amendment was that they would not name any healthcare providers in any COVID-related suit. I will say that that really was an amendment without substance. Brick and mortar hospitals don't go to court, people go to court, and defendants go to court. And the way the medical malpractice litigation process works is that a plaintiff has to file something called a certificate of merit before the case can go forward. And in that certificate of merit, they need to name all healthcare providers who they allege breached the standard of care. So even though the physician's or the nurse's name might not be on the front part of the suit, they have to be in the certificate of merit. And healthcare providers would need to be deposed, and they would need to be active in the litigation. And if the case were to go to court, they would need to be sitting at the trial table defending their care. So although it was an offer, an amendment, I would say that it really was not a substantive offer, and certainly not one that addressed the concerns our healthcare providers have. Thank you.
I think my perspective on this as a 30-year practicing surgeon and still practicing, Congressman, is I firmly believe that every person should still have their day in court. And this legislation does not change that. Malpractice exists, as you know, because malpractice still exists. But what we're asking is a very surgical and tactical approach to modifying what is currently the legislation that allows protections where there's no set standards. During this crisis, and again, I appreciate the previous Congresswoman's comments around that the jury will understand it. Unless the jury has sat in an ICU and watched the surge of 2 to 3 times the normal capacity and watched patients dying in an ICU in the biggest crisis of our lifetime, and I've been practicing a long time, this is the biggest crisis that any of us have ever experienced, to understand that we're trying to make some modifications on legislation around standards of what is a healthcare provider. Standards beyond the point of COVID patients and an extension for 180 days. It's not blanket, Congressman, but it is a tactical approach, a surgical approach, if you will, to modification.
And Delegate,
We're all very pleased with the promotion you've given us, but we're merely delegates. We don't go to the place down the street. But
Thank you, Chair. Thank you.
Appreciate that. There was a third part to Delegate Cardin's question. I'll let that be answered. Please go ahead.
Yes, thank you, Mr. Chairman. Thanks, Delegate, for that question. So you brought up the Attorney General's opposition letter. Yes, we are aware of that. I think you all have heard pretty clearly our intent behind this bill, very narrow updates to take into account the unique challenges of responding to the pandemic. I will say we did meet with the Attorney General on Monday. We walked through our intentions and we're committed to working with him and his team to address their concerns.
Okay, thank you very much. Now we'll go with Delegate Moon, then McComas, then the Vice Chair. Delegate Moon.
Thank you, Mr. Chair. I just have two questions. One, if you could just, I just want to be frank about what we're trying to do with this bill here. Would you agree that if we pass the bill, the very practical result will be that there are claims that are currently ordinarily good claims that after passage of this bill would no longer be viable? And I think that is what we're getting at here. And two, what that leads me to is I'm a little concerned with a very specific part of this bill, and it's on page 2, lines 23, line 23 or so. Because if what you're trying to do is strike down claims that ordinarily would be good, that section seems to say that we would get rid of claims for an omission that is indirectly related to the emergency. So the way I read that, it's saying the doctor forgot to do something, and indirectly could just mean we were all overworked, as you are suggesting, that the overall system and state of the health system would give cause to basically give all claims under the indirectly that happened during COVID. I don't see how, if you're saying the whole system was inundated, that doesn't mean all claims are going to be indirectly related to COVID, especially if we're saying also it's not just acts, but omissions. Forgetting to do things during COVID indirectly related to COVID, to me, means we would be taking out good claims and making them bad claims if they happened during COVID and the hospitals claiming they were busy. Am I reading that incorrectly?
Maybe I'll start. Are you reading it incorrectly? That's a hard question to answer. I can tell you I would disagree with you that we're taking good claims and then making, not allowing a patient or a plaintiff to pursue them. I think what is so integral to this analysis is it's good faith. We're trying to make it fair for the providers, fair for the patients in a 100-year pandemic. So we are not saying you can never bring your lawsuit. What we're saying, and to your point, let's say the point, the overworked physician, is that indirectly related to COVID? Well, part of it goes into good faith. And so as part of bringing their case, the plaintiff could show that by this omission, this physician was not acting in good faith because he wasn't overworked, or there weren't any of these things that would cause him to be acting in the way that he was acting. So this does not, and this is what we've struggled to really get this point forward, which this is not a blanket, you do not get into court. That is not what this bill is. This bill is simply saying, yes, you can file your claim. And then we as a defendant, if we believe that COVID caused some of our providers to be under stress or whatever, we will file the affirmative defense. 1 of 20 in Maryland, statute of limitations is an affirmative defense. And at that point in time, the plaintiff can put on evidence that will demonstrate that this defense of immunity should not apply. And if a judge agrees with the patient, then the patient's case will go forward and proceed through litigation. So it is not just simply a matter of once this statute goes into effect, no one will be able to go into court. That's not it at all. All we're simply saying is under these extraordinary 100-year conditions, when we are doing things that we have never done before, we are doing things where there is no established standard of care, the physicians or the healthcare providers acts really needs to be judged in a different manner, and that manner is good faith.
I'm sorry, Mr. Chair, if I could just one very quick follow-up. So just to be very clear about this, like I get the ICU scenario you're pointing out. But that's directly related to what's going on with COVID. But like a podiatrist in a non-emergency capacity in a hospital system that may be overwhelmed, like, is it your view that somehow that's going to come into this bill?
Well, I think I really appreciate this question, because I think we would all be happy if everybody agreed that any ICU that is overwhelmed, but the ICU doesn't just have COVID patients. We are treating COVID and non-COVID patients. And I think one of the things that we are very concerned about is Secretary Neal's amended order that essentially said that that the immunities afforded under the public safety article and the health general article may not apply to non-COVID patients. And our ICUs are filled with both. We are treating both throughout the hospital system. And even more importantly, when you direct resources one way, all patients are going to be affected. So, the podiatrist, I guess what I would say to that is, it depends on where the podiatrist is treating a patient. We have podiatrists who do surgeries in our hospitals all the time. Those resources are utilized just like all of our other specialties. And I think, the thing not to forget is really that when these questions come up, a judge will be able to decide when the immunity applies and when the immunity does not apply. So the plaintiff will have the opportunity to make many of the arguments that you've made today as to why should immunity apply.
All right. We're going to go now to Delegate McComas, then the Vice Chair, then Delegate Griffith.
Thank you, Mr. Chair. Just briefly, you need an expert to basically certify that the case has merit to go to the Health Claims Arbitration Commission, and then they try to arbitrate, and if it doesn't work, then it's got to go to court. Is that fair to say? It's kind of that's the quick and dirty. So basically, the expert doesn't have to be from the state of Maryland. It can be anywhere in the country. But every state has handled COVID differently. Is that fair to say? New York, Governor Cuomo versus what they've done in Florida versus what they've done in California. I mean, every state kind of has a unique spin on it. So in these cases, when there's an expert evaluating what went down in Maryland, they're going to have a lot of studying and coming up to speed as to how Maryland handled what the standard of care was in the state of Maryland. Because would it be fair to use the standard of care in, let's say there's a doctor, they're licensed in New York, and come to Maryland and then say, hey, this is what our standard of care is, when it's going to be entirely different? I mean, could you just kind of comment on that, how this is going to work with these lawsuits?
I'd be happy to. I think that's an excellent point, because all of the treatment has developed at a different pace. Supply chains are different across the country. You look at some areas that have been really heavily impacted that actually were very concerned they wouldn't have enough ventilators. If you have an expert coming in from a hospital out of state that does not or had not worked under the same stressors that our hospitals were placed under, didn't have the same conflicting priorities, they can testify only to what they know. And what they know is what was happening in their state, maybe, if they even worked at a hospital that has an ICU, because it doesn't necessarily mean that you're going to have a hospital, an expert from a hospital who actually has the same facilities and the same different specialties that the hospitals that might be brought into these lawsuits. It is very, very different. And I think that is what we're really trying to help everybody understand, is that this is not every day as usual. This is a 100-year pandemic where we have done everything we can possibly do to pivot and shift and modify how we've done things. And some of the things we did in the beginning, we learned were not the right things to do, but they were the right things to do at that time. And people who are out of state, who really aren't familiar with, number one, our regulations, number two, the proclamations that we might have been under at the time. To your point, exactly, they would have to do a lot of research to really try and understand and appreciate the exact situation that our providers were under at the time. And those conditions change hour to hour, day to day. We get a tracker board every morning that looks at several different metrics, and some hospitals are in red, some hospitals are in yellow, some hospitals are in green. And I think, in medical malpractice, we deal with the Monday morning quarterback every day, and that's okay. That's okay in your usual medical negligence case. But it is not okay in a pandemic, when everybody is really trying to do the best they can, learning every single day how to approach the different challenges that face us. And that's why this immunity is so important.
Thank you.
Thank you. The Vice Chair.
Thank you, Mr. Chair, and thank you everyone for being here today. I'm just going to follow up on a couple of things that were already said. If I could just, I guess, get your comment on them. First, Delegate Cardin, he discussed the Attorney General's letter where they are opposed to this piece of legislation. But I want to point out, they specifically talk about how that this legislation would have a disproportionate effect on lower income communities, people of color, people who already have access to justice issues. So I was wondering if you could comment on that. Also, if someone could comment on perhaps I missed it, just the retroactive provision. I mean, the Constitution says retroactivity is unjust. And I mean, that's spelled out clearly in the Maryland Constitution. So I'm wondering how you kind of jive that with the legislation. And then the Attorney General did also mention that the legislation would preclude them from going after nursing homes and other, air quotes, healthcare providers that sell fake, cures to the virus that some folks might take. So it would be preventing them from seeking justice for Maryland residents. And then my last comment, it is a question. So there will be a, isn't that so, perhaps, or I'll just ask if you could comment on that. So we've had a lot of discussion about juries. And so the Constitution also says that we have a right to a jury. And what I'm struggling with are the comments that jurors can't understand. I think, jurors, a lot of jurors sit in judgment and have to make decisions of things they may not have personally experienced, like rape, like murder, like, arson, like human trafficking. I mean, some of the most horrific things that you could possibly imagine, but it's their right to do that. And it's our right to have them hear those things. So I'm just wondering if you can comment on why we're discrediting jurors so much in terms of they're not going to understand. I mean, the longer this pandemic stretches out, the more I'm finding people that I know, and I'm sure everyone on the Zoom knows, have someone who's been affected. I mean, at this point. So I think if you got a pool of jurors together, you would have at least 4 people in there who have been touched somehow by the pandemic. So I know that was a lot.
Yep. Thank you so much, Vice Chair, for that those comments. I'm going to start and then kick it to Ms. Kinter for the retroactivity and Dr. Coots on the disparities piece. But I did want to address your last comment as well as the Attorney General. Let me start with the Attorney General question. So in terms of the piece in there around organizations that are selling fake remedies for COVID, that is not our intent to cover those types of issues in this bill. I think we've made that pretty clear. And let me just say, too, that we are more than happy to sit down with this committee to make sure that our bill is laid out in the correct way that's aligned with our intent. We're happy to come to the table and work on language to make sure that's the case, because, again, we certainly do not want those types of activities to have liability protections. I also want to reiterate what we said earlier around we are not seeking to take away anyone's day in court here. Anyone would still have the ability to file a lawsuit and go through that system, but there would be this good faith standard in the law, which is already there. We're seeking to update it based on what we're experiencing during the pandemic. But I just want to make sure that that's very clear. And then to your last point, we certainly have a lot of respect for jurors. I think the point that we're trying to make here is that things are changing constantly with COVID. They have been since the very beginning back in March of last year. We have federal and state directives that are changing constantly. We have public health guidance that's changing constantly. The science behind COVID is changing constantly. We're now seeing new variants of COVID where it's transmitted differently, and that's likely to continue into the future. And so I think we're just, our point is we want to make sure that there's an acknowledgement that if cases are filed in the future, that there's an understanding of the all hands on deck approach our system had to have in response to a crisis that no one has ever seen before, and one that that is changing consistently. So I think that that's what the point is there. We certainly, again, no disrespect at all to jurors or anyone else in the court system. And again, we do not want to take away anyone's day in court. That is not the intent of this legislation. But if I might, Mr. Chairman, if I could kick it to the rest of our panel to address the rest of the Vice Chair's questions.
I'll be quick on retroactivity. And again, we don't mean any disrespect towards jurors. I think my colleague spoke very well in exactly what our concerns are. As far as the retroactivity, we do not believe that the retroactivity that's in this bill is unconstitutional, because we are really simply trying to affirm and clarify the immunities that are already available under the Public Safety Act and under the Health General Act. We already have immunity. We've had it since 2002. But again, Secretary Neal's amended order kind of muddied up exactly, really what that immunity may or may not apply to. And because we already have immunity and we're simply trying to clarify what is already in legislation, we do not believe that the retroactivity is unconstitutional.
Madam Vice Chair, I'll address the health equity and health equality, which is what I think you're getting at. So health equality means everyone has access to the same level of care, and health equity is that everyone gets individualized care, the right care for them. And certainly we have made it a concerted effort across all the hospitals in Maryland, the Maryland Hospital Association, to ensure that we eliminate the disparities in healthcare that are seen. This disease already has laid bare the health inequity issues. It has impacted communities of color. I mean, our patients certainly are 55% Hispanic and 39% African American, and then the rest, all the rest, that's in the COVID. In terms of the patients that we see, at least for those of us in Montgomery County, Prince George's County, and Baltimore County, we live in very diverse communities. Our patients are already very diverse. Our staffs are as diverse as our patients are. And so if it's an issue of bias or something like that, I mean, that is something that always has to be teased out, but it's not that impactful in this. What maybe has more of an impact is when we have done things like our ethical processes around the conservation of scarce resources, those ventilators or things, who gets this or who gets that. We have done our best to factor out any of those discriminators and neutralize everything. So we're looking at the individual patient, the individual case, who will best benefit from this treatment or that treatment. Is it 100% foolproof? No, I mean, we're all humans and humans have some biases, but we do the best that we can to eliminate those biases in all aspects of care.
Thank you, Mr. Chair.
Thank you, Delegate Griffith.
Thank you, Mr. Chairman, and thank you, Delegate Coulson, for bringing this bill forward. Just kind of a scenario question, just trying to unpack what this bill does. So, I mean, what if a dermatologist fails to properly diagnose a cancer patient in their office? Would that be immune under this bill?
It depends upon if that dermatologist, again, it goes back to whether or not there's a finding of good faith, right? So the real question is, will that patient be able to take the case through the litigation process? So the first question is, there would be a determination as to whether that physician acting under that circumstance acted good faith in missing the diagnosis. If the diagnosis was missed because the dermatologist could not take this patient to do a biopsy because non-urgent patient or non-urgent procedures, the hospital could not accommodate any non-urgent procedures, then we would argue that physician acted in good faith. The hospital told him you cannot schedule this procedure. That physician, acting in good faith, made an analysis that this was a procedure that was not an emergency procedure. It could be delayed. And if there was a delay in the diagnosis as a result of that delay, because non-urgent procedures couldn't be scheduled, we would argue that immunity applied and the affirmative defense would be successful.
So a dermatologist believing there's a possibility this individual has cancer, that's not considered urgent?
Well, it all depends. It all depends. We have a whole list. So what is listed in kind of our absolute emergent are people who have, for instance, an aneurysm that needs to be repaired that could rupture at any moment, appendicitis, a brain aneurysm. So there is a schedule our hospital has put together. We have a committee that looks at these things, but a biopsy for cancer, depending, may or may not be considered emergent, that it needs to be done within the 72 hours, the 4 weeks, the 8 weeks. I will tell you that there is a process that we have in place in order that those decisions can be done thoughtfully and that it is done, I will say, by committee, and that there has to be a discussion with other individuals. But yes, even though cancer is a very scary diagnosis and it's very worrisome for the providers as well, if that provider can't schedule a procedure at a hospital, then that provider should not have to go through the litigation process because he could not schedule that biopsy procedure.
I mean, I think that impacts a larger point, the concern being if determining if somebody has cancer is not considered, even by the hospital, a critical procedure. I mean, for me, if I had a grandmother that was facing a cancer diagnosis potentially, I would expect that to be a critical diagnosis, especially when you're looking at potentially life or death on the line down the road. So thank you very much. I appreciate it.
We don't disagree. It's just, can the hospital during a COVID crisis be able to manage that particular procedure with no bed to send that patient to, no time on the OR schedule to schedule it. I agree with you, and it's very challenging and it's very concerning for the providers as well.
Thank you.
Okay, that is our first panel for those people who are testifying in favor of House Bill 25. Now we're going to go to the second panel, and that panel includes Allison Taylor, Robert Linton, wasn't sure if Steve Wise made it on the call, but just in case, Steve Wise, Ashton DeLong, Michael Sanderson. After this panel, there's one person who's favorable with an amendment, Lauren Kellens from Max, so we'll take her separately. But we'll do those 5 people right now. Start with Allison Taylor for 2 minutes, please.
Hi, good afternoon, Mr. Chair and members of the committee. This is Allison Taylor on behalf of Kaiser Permanente. Thank you for having us today. There's been a lot of discussion on this. Really, I'm just a me too in support of this bill. Kaiser Permanente has 5,000 healthcare workers in the state. We have 18 facilities in 10 counties. We've been working very hard all year to provide the highest level of services that that is possible. We really support the bill and urge a favorable report.
Thank you very much. We're going to go now to Robert Linson.
Good afternoon, Mr. Chair.
Yes, please.
Thank you so much for allowing me to speak here on behalf of this bill. I represent Maryland chapter of American College of Emergency Physicians. I'm the current president of that organization, and also I'm speaking on behalf of MedChi. This bill is extremely important. I've been a practicing emergency physician for over 20 years. This is unprecedented times. In particular, the standards that change, especially early in the pandemic, change from week to week, day to day. Hydroxychloroquine is one example. That medication was initially touted to offer some benefit, but it turns out not only did it not offer benefit, there was potential for harm. So we discontinued use of that medication. In addition, steroids is also another treatment that we later found to be beneficial, and we adopted. These standards changed from day to day. We would be doing managing these patients one way one week and then a different way the next week. PPE, personal protective equipment, we have to wear that to protect ourselves, and it has actually presented some challenges, even with communicating with our patients. There are HEPA filters in rooms that we have to use to protect the air exchange. And that goes for COVID and non-COVID patients. That's difficult to hear in some of the respirators. And it presents a challenge even on that level. Patients that present critically ill to the emergency department, we can't just, if they come unannounced, we can't just rush into the room as we would pre-COVID. We have to put on an additional layer of protection. And that adds, we've gotten very good at it, but it adds a little delay to that. So I know my time is short. I do want to state that this, we need the additional legislation to more accurately reflect the changing environment and landscape that we, and complexities that COVID-19 has brought to bear on the healthcare system. And our healthcare heroes should not have to worry about claims that assume negligence, when in fact we're doing our very best to adapt to the changing environment and complexities that COVID-19.
Thank you, Dr. Linton.
On the healthcare system.
All right. Thank you very much, Dr. Linton. All right, we're going to go now to Ashton DeLong.
Hello, Mr. Chairman and members of the committee. Thank you very much for hearing this important bill. I'm Ashton DeLong, and I'm with Medical Mutual Insurance Society of Maryland, and we are here also as a Me Too. I think there was some great discussion with the last panel, so I would just submit on our written testimony and urge the committee for a favorable report on HB 25.
Thank you very much. And we'll go now to Michael Sanderson.
Thank you, Mr. Chair. Committee members, I'm Michael Sanderson with the Maryland Association of Counties on behalf of our workers who are in ambulances and firehouses rather than hospitals. Me too.
All right. I don't believe Steve Wise entered the waiting room with, don't mean to necessarily call him out, but he is not here. So we're going to go ahead and take any questions for this panel. Seeing none, we thank you all very much for your testimony in favor of House Bill 25. We'll now go to one person to testify favorable with amendments. That's Lauren Callens from MACS. Is Lauren here? Oh, wait a minute. Delegate Cham raised her hand after I looked down. Delegate Cham, do you have a question?
I did. Sorry.
Dr. Linton is still here. And the sponsor is still here. So we have a couple still here. If you think you can go ahead and ask the question.
Yes. Thank you. I apologize. I was
right.
Trying to get to my unmute button. The question that I wanted to ask is regarding the difference between negligence, and bad faith. Those, that verbiage can sort of overlap, but I'm sure there's some major differences in how those words are defined. So if any of the panel members could sort of explain the differences between those three words, concepts or whatever.
Unfortunately, I'm at a disadvantage because I am not a lawyer.
I will defer.
I'm an educator.
Yeah.
That's right.
So here, Delegate Cham, this is what we will do. We will, that's an important question. And I apologize that I let people off the call before, and I caught your hand a little too.
No problem. No problem.
We'll get answers to those questions for you.
Thank you, Mr. Chair.
All right. With that, we'll go to Lauren Callens for 2 minutes.
Thank you, Mr. Chairman, Madam Vice Chair, and members of the committees. My name is Lauren Callens, and I'm with the Maryland Association of Community Services. We represent over 100 providers of community services to people with intellectual and developmental disabilities. We're here today in support with a single amendment, a very narrow issue compared to some of those that you've all been discussing here today. And this is an issue that was created when the original statute was enacted in 2002. And that is that as currently drafted, the existing statute covers developmental disability administration licensed group home providers, but it does not include DDA licensed providers who are licensed to provide other services beyond group homes. And sometimes these providers are providing the exact same services as the group home providers, including medication management and an array of nursing services. Further complicating things is that many of the group home providers who are licensed by the DDA are also licensed to provide these other types of services, including meaningful day and in-home supports, and sometimes to the same people as in their group homes. However, only a claim arising out of their group home supports would be eligible for the immunity under the statute. And so for this reason, we are respectfully requesting an amendment that would include all DDA licensed providers as defined within Health General 7-101. And that is all I have for you today. And I thank you for the opportunity to raise this issue.
All right. Are there questions for Ms. Callens? Giving it a second. Seeing none, thank you very much. And that concludes the testimony for those people who are in favor or favorable with amendment. We'll now go to the opposition for the bill. And they are Christopher Norman, Anna Palmisano, Patrice Clark, David Wildberger. And those are the first four. And I think that's what well, there are another five. So we'll add Emily Malarkey to this first group. Emily Malarkey to the first group. And so we'll hear from these five, and then we will go to the next five. And those are Mary Coe, Patrice Clark, Kelly Donahue, Patrick Thronson, George Tolley, and Ellen Flynn. So, all right, to begin, we'll go to Christopher Norman.
Thank you, Mr. Chairman, and members of the committee. My name is Chris Norman. I've heard some of the proponents of this bill in their testimony suggest that the bill does not take away an individual's rights to their day in court. Allowing someone to bring a claim only to have that claim immediately and summarily dismissed because of this new law and the new standards that it creates is clearly the equivalent of taking away an individual's rights to sue and to have their day in court. The suggestion that this bill doesn't affect an individual to have their day in court is hollow, it's misleading, and it's disingenuous. I also heard some proponents of this bill suggest that it is constitutional because it is not retroactive. I would point the members of this committee to the website of the Medical Mutual Liability Society of Maryland's website, which is the largest individual insurer of healthcare providers in the state. On their website, it says, this, in speaking of the current Immunity Act, this statute provides a healthcare provider with immunity from civil liability if that healthcare provider acts with good faith under a catastrophic health emergency proclamation. Maryland Governor Hogan issued such a proclamation pursuant to the Maryland Code of the Public Safety article, and renewed that proclamation on May 6th of 2020. To fall under the immunity protection of this act, certain conditions must apply. Number one, if you are providing normal routine care for a non-COVID-19 patient, then the immunity of this act would not apply because that care has no relation to the catastrophic health emergency proclamation of the governor. The largest individual insurer in our state says that the law as it exists currently does not provide immunity protection for care to non-COVID patients. This law clearly and with intent retroactively goes back in an attempt to alter or amend that law and to strip away the constitutional rights of individuals who have claims now. It is unconstitutional, and I urge your unfavorable vote. Thank you.
Anna Palmisano, please.
Good afternoon, Chairman and committee members. I'm Anna Palmisano. I'm a PhD microbiologist and director of Marylanders for Patient Rights, a patient advocacy coalition including AARP and Disability Rights Maryland. We strongly oppose HB 25, a bill which threatens to undermine the rights and safety of Maryland hospital patients. Healthcare and other essential workers are clearly facing many challenges, but hospital patients are also facing extraordinary challenges. Many are not allowed the support and comfort of a family member or a patient advocate. In 2019, a hospital patient's Bill of Rights was supported by 24 advocacy groups. It was passed unanimously by the Maryland General Assembly and signed into law by the governor. It's notable that the Maryland Hospital Association fought against those patient rights for 4 years. HB 25 threatens to undermine patient rights by denying patients legal recourse for egregious medical errors, patient dumping, or discrimination against vulnerable patients and minorities. First, HB 25 will greatly expand the number of employees who will be free from civil or criminal liability for any wrongdoing towards patients. It will allow bad actors to avoid consequences and the neglect or abuse of patients to be tolerated. Simply put, there is no accountability. For example, the University of Maryland Medical Center security guards who left a vulnerable young Black woman half-clothed at a bus stop on a freezing January night would be free from liability. Second, a 6-month extension of freedom from liability is not justifiable and puts patients at additional risk. This bill is ill-conceived and has the potential for grievous harm against vulnerable patients, including the elderly and disabled. I strongly urge you to provide an unfavorable report for this dangerous bill. Thank you.
Thank you. I'll go to the next page. Patrice Clark.
Good afternoon, Mr. Chairman and members of the committee again. My name is Patrice Meredith Clark. I'm a trial lawyer in Pasadena, and I'm a member of the Maryland Association for Justice. Fortuitously, I want to talk about Delegate Cham's question about what it means for a healthcare provider to be acting in good faith. You all heard Ms. Kinter testify, quote, "The defense available to us is good faith. It is not a free pass. If the plaintiff does prove that the physician did not act in good faith, that does go through the process of litigation," end quote. Now, that sounds like it makes sense, right? That so long as the healthcare provider was doing the right thing, then they should be immune from liability. But good faith is not the same thing as doing the right thing under Maryland law. Under this bill, to survive a motion to dismiss, victims will have to prove the opposite of good faith, and that's bad faith. Maryland's Court of Appeals has explained that bad faith is not simply bad judgment or negligence, but implies a dishonest purpose or some moral obliquity and a conscious doing of wrong. So, in order for a victim of a medical injury to maintain a lawsuit under this bill, they would have to prove that the healthcare provider provided the care with a dishonest purpose or with conscious wrongdoing. In other words, victims would have to prove an intentional tort, not a negligence claim. As a plaintiff's lawyer, I can tell you I represent victims of medical negligence. We very rarely see cases where doctors intended to harm patients. Doctors are not in the business of hurting. They're in the business of helping. Requiring that victims of medical mistakes prove that the doctor intended to harm or knew that what he or she was doing was wrong takes away victims' rights to recover. The point was made that healthcare providers will have the opportunity to present evidence of the pressures of COVID as part of their defense. Ms. Kinter said that she does not think a reasonable juror could possibly understand the pressures that healthcare providers faced. Well, respectfully, as a medical negligence attorneys, we expect lay jurors to understand complicated medical issues all the time. In the brief reopening, I tried a case in November of this past year involving ureteroscopy with holmium-assisted laser removal of a kidney stone. So we expect jurors to understand very complicated medical issues all the time. That's what we expect them to do. And that's the point of the jury system. The last point I want to make very quickly.
Very quickly, if you could please wrap that point up, please.
Okay, the sampling that was referenced by Mr. Frazee is just on page 16 of their written testimony, and it's just screenshots of things that say things like, can I sue for medical malpractice related to COVID-19, question mark. I urge an unfavorable report. Thank you very much, members of the committee.
Thank you. All right, we're going to hear from Mr. Wildberger. Committee, I have to step away for a moment. Vice Chair will take over from here, but 2 minutes for Mr. Wildberger. Then Emily Malarkey, and then there will be time for questions. So thank you very much for that.
Thank you, Mr. Chairman, Madam Vice Chair, and committee members. David Wildberger again, Maryland Association for Justice. There really isn't any argument presented that this bill is constitutional. There's no argument presented that it doesn't retroactively, adversely impair accrued rights. Now, there's two excuses given. One is, well, we're not really changing anything. Well, let me follow up with what Ms. Clark just said. Currently, the actions that potentially could be brought regarding care from May 5 to current are negligence actions. A negligence action alleges that a healthcare provider practiced outside the standard of care. The standard of care is that level of care provided by a practitioner in the same or similar circumstances. The circumstances of COVID. And believe me, everybody's going to understand what's going on in COVID and what's going on in the hospitals. To say that jurors can't that's disingenuous. Now, the other thing that they say is, well, we had this immunity before and it covers all this stuff we want now. Well, that's not true. I point out to you that last spring, the big healthcare provider, what I call big medicine, went to Governor Hogan and said, we want you to construe this current immunity the way this bill reads. A Republican governor in the state of Maryland said, went to his Department of Law, got an opinion, said, no, that's not right. That's not what was intended. That was never intended. What they really want, they want a year or more of having no lawsuits for negligence. They want a year or more of having only to defend lawsuits that can allege and prove an intentional act, which is a burden that nobody's going to be able to meet. And you're going to have a lot of negligence cases that are not going to be able to be pursued because of that. And that's exactly why it's unconstitutional. You can't take a right in a vested cause of action, an accrued cause of action for negligence.
Thank you.
Retroactively say, no, you now have to prove a different cause of action and intent. I urge you, unfavorable report on this bill. Thank you.
Thank you, Mr. Wildberger. Now we'll have Ms. Malarkey for 2 minutes.
Yes, thank you, Vice Chair, members of the committee. My name is Emily Malarkey on behalf of the Maryland Association for Justice. I would like to address the comments that were made by the proponents of the bill that this bill simply clarifies the existing law. I think we heard through a number of the attempted answers at some of the questions of the proponent that in fact that's not true, and that what this bill in fact does is expand the current law in at least 2 very significant ways. We've talked about this a little bit, but I just want to focus in on those 2 ways. One is that the law expands the definition of who is a healthcare provider. And as was raised, that would include everyone from the janitorial or custodial staff who fails to mop up a spill of water in an obstetrical unit and causes a pregnant patient to fall and hurt herself and her unborn baby. It would include security guards who assault a patient on the premises of a hospital, or as the example that we just heard a moment ago, left someone out in the cold in the middle of the winter. It would even include parking lot attendants. It is so overly broad as to almost be comical. The other way in which this bill is overly broad and an expansion of the current law, as we have heard, is that it applies to treatment that has nothing to do with COVID, and treatment that, in fact, under today's circumstances and the technology we have, can be rendered from the comfort of doctors' own homes. So it would apply to a radiologist reading a mammogram literally from his home and failing to pick up that someone had breast cancer, or a pathologist who looked at a liver biopsy or a skin biopsy and missed someone's cancer, or a cardiologist who could read an EKG and miss a heart attack. Or the most extreme example that we can talk about is cutting off the wrong leg for a patient that needs an amputation. And we might hear in response to that, well, that would never pass the good faith standard. But in fact, it would, because we know that bad faith requires intent. And as long as the healthcare provider could say, whoops, I made a mistake, but it was an honest mistake and I didn't mean to do it, that suit couldn't be brought. Those are two overly broad expansions of the current law. What this bill is attempting to do is take advantage of a crisis to leverage it into broad protections for hospitals and doctors that simply should not be given. We shouldn't strip away patients' rights.
Thank you.
Yes.
Can you want to wrap up?
I sure will. I will just urge an unfavorable report and I can answer any questions. Thank you.
Thank you.
I missed the timer, I confess. I'm sorry.
Are there any questions? I don't see any. Okay, thank you very much. And we will move on to.
There is a question, Madam Vice Chair. I see Delegate Cham. Do you have your hand raised?
Oh, I didn't see it. Delegate Cham, go ahead, Delegate Cham.
Sorry about that. Thank you, Madam Vice Chair. I was moving the mouse around. I'm ready to unmute and raise my hand as you were wrapping up. This may be a better place for me to ask the question earlier that I had, because I heard it sort of the answers to my questions slowly coming up. And Mr. Wildberger, if you could please help me with this, and others if necessary, regarding the difference between negligence, gross negligence, and bad faith. I mean, it's all sort of like there's some merging there with those terminologies. But if you could kind of help me and maybe the committee, if there's any misunderstanding about those terms.
Absolutely. I'll take a first stab at it, and I'm sure that my colleagues will correct any mistake I make. Negligence is a concept that involves an allegation that someone acted unreasonably. A doctor is held to the standard of acting the same as a reasonable practitioner under the same or similar circumstances. Now, again, I said before, the same or similar circumstances is COVID in this context. So negligence is simply making an unreasonable mistake. Not any mistake, but an unreasonable mistake. Now, good faith, to disprove good faith, you have to prove bad faith. And the Maryland Court of Appeals says that bad faith, being the opposite of good faith, requires much more than negligence. It requires dishonest purpose or intent. Dishonest purpose or intent. And again, what they're doing is they're trying to kill all negligence cases retroactively and prospectively for whatever period of time and substitute a burden that nobody's going to be able to meet. Now, the other term that you will see is gross negligence. Gross negligence, the Court of Appeals says a wrongdoer is guilty of gross negligence only when he inflicts injury intentionally or is so utterly indifferent to the rights of others that he acts as if such rights did not exist. This is a very different burden than negligence. It is a completely different cause of action. It is intent. And that is the difference here, Delegate. The difference is negligence, which is a mistake, an unreasonable mistake, or intent, which means I intend to harm you. Does that answer your question?
Yes, it does. Thank you very much, Ms. Wildberger. Thank you.
Are there any other questions for this panel? Delegate Cardin?
Thank you, Madam Vice Chair. Just real quickly, we've been getting into this discussion on good faith, and I just want to make sure I understand the bill correctly. Isn't good faith already in statute? Isn't that the burden that they have to overcome at this point?
It is not. It is not. The burden you have to overcome is that of negligence, a reasonable provider under the same or similar circumstances. Good faith, bad faith is a much higher standard that we don't generally see in practice. It is very, very different. As the Court of Appeals said, it's the opposite. It is not negligence. And no matter how the proponents of the bill want to conflate that.
Right, but I thought that with the immunity that's been given thus far, that the governor, I guess, put in, isn't good faith the standard there?
Good faith is the standard in the existing immunity, and that's our point for why they don't need to expand it. They already have an immunity that applies to all treatment provided regarding COVID, directly provided COVID. They have it in two different places in the code, and that is a good faith standard. So they have the higher level of proof standard now, but they want to take it across to all cases.
No, I understand. And the question is the argument as to whether that standard that's already in existence presently should be extended to, doctors who an obstetrician who was brought over to the emergency room because they needed an extra doctor. So she or he is not doing what they would normally do. They are qualified to do it. And so they wouldn't be held to the good faith standard. They'd be held to the negligence standard.
And that would all come into evidence at trial. And frankly, there is a reason they have the good faith standard now. It is because it is a very hard standard for anybody to meet. Governor Hogan refused to expand it because presumably his Office of Law has told him he couldn't. This goes to the heart of the retroactivity of this bill. This bill seeks to retroactively change the standard of an accrued cause of action from that of negligence to an intentional tort. And those are two very, very different things. If I have a case where I want to allege both of those things, I have to allege them separately in separate counts because they are two different causes of action.
Thank you.
If I could piggyback really quickly, Senator or Delegate Cardin, and just answer, you said would the good faith standard apply to an obstetrician who was brought over to moonlight in the ICU because they needed more doctors for COVID. Well, that's covered under the current immunity under section 14-3A-06 and the other immunity in Health General. So that's already covered and they already have that higher good faith standard. What we're talking about is the podiatrist, which I thought was a good example. So that is what they're trying to extend it to, is that good faith standard to all healthcare providers that is somehow related to COVID, which everything is related to COVID. This Zoom call is related to COVID, right? So that's what they're trying to extend it to, not to the obstetrician.
And if I'm sorry to piggyback again, but if I may just add that in the situation with the podiatrist, there's still absolutely that podiatrist entitled to argue under the existing law that there was some COVID-related circumstance that prevented them as a podiatrist from meeting whatever standard the plaintiff says was breached, because that's the fluid definition of standard of care that we have already built into our law. So we're not taking away the right to defend the case on any potential COVID-related grounds either.
Next, Delegate Davis, Deborah Davis has a question.
Thank you, Madam Vice Chair. My question is in general, if you could address the thing that keeps popping in my head is that what is the incentive for not having doctors overworked or overstressed if they have immunity? I think the doctors should be more concerned about this, and the podiatrist and the allergist and all those people. Yes, could you address that if you could?
What is their incentive for not being overworked or for being overworked? I think I've misunderstood the question.
It becomes apparent to me that if they're immune from overworking them, if they're immune from overstressing them, what incentive do the administrators have for not continuing that practice?
Absolutely none.
Right.
I think that's a great point, Delegate. What the laws do sometimes is encourage or discourage certain actions. And in a setting like this, what we want to do is try and create an environment where all patients can get the best possible care under the circumstances. And if you have a situation where there is blanket immunity for all healthcare providers for every action, then there's no encouragement or incentive to do things as safely as possible under the circumstances.
Okay, now I do not see any other questions for this panel. Thank you very much. And so the final group of folks coming on to testify opposed to the bill: Mary Koch, Kelly Donahue, Patrick Thronson, George Tolley, and Ellen Flynn. Now I do not. So we'll give everyone 1 second to get connected here. And everyone will have 2 minutes to testify. Okay, I'm told Ellen is not here, so. Okay, Ms. Koch.
Hi, how are you? Good afternoon, everyone. My name is Mary Cook. I'm in a.
Oh, sorry about that.
Oh, no, no worries. Trust me, I've been called much worse. No problem. My name is Mary Cook. I'm a plaintiff's attorney. I work at Waste Vogelstein, and I'm a member of MAJ. And I actually was going to talk a little bit about standard of care was my plan, but Vice Chair, you asked a question about the disparity that was caused by this bill. And I actually want to address that because I don't think the question was answered. Because I think when we're talking about the disparity that's caused by this bill, the answer to the question that you got was the attempts that the hospital makes to ensure that there's equal access to treatment once a patient is in the hospital. And that's very different than the disparity that's caused by this bill, because what this bill does is, by depriving people of their day in court, it takes the people who are less able to financially shoulder the burdens of an injury related to medical malpractice and leaves them without a remedy. And that is the disparity in a bill like this, because when you deny access to the courthouse and you deny people the ability to put their case in front of a jury and to recover for the injuries that they've suffered, they are now forced to shoulder that on their own. And we know in this economy especially, many people are not able to do that. And it is not a secret that we have seen, and it's an issue that's been brought to light, that those disparities go across racial lines, and they affect inordinately people of color and people in lower economic status. And so it's a huge problem. And I think that I want to take that and sort of ride into the second point that I wanted to make, which is about the standard of care. I spend my time now handling complex medical malpractice cases. Many of the cases I handle have to do with obstetrical issues, kids that are injured at birth. Those are complicated medical issues. And my job as a lawyer is to explain those complicated medical issues to the jury, to present evidence for the jury to understand it. That's my job. That's the job of the lawyers that represent the hospital. We all have to act that and do that within the standard of care. The standard of care is extremely fluid. It allows the hospitals to present evidence related to all of the circumstances that related to the care and that would influence the care, because that is what dictates, as the standard of care is defined, it's what a reasonable physician would do under same or similar circumstances. The same or similar circumstances are COVID. Our law already allows for all of these types of variations. And so there's no reason to pass a law that shuts the courthouse door to people who are in need, who should have the right to litigate and have a jury decide, as the Constitution allows, the issue of whether or not they've been harmed by medical malpractice. And I'm
gonna have to ask you to wrap up.
All I would say is, I think you've heard from all of my colleagues. I'd adopt what they say and ask for an unfavorable report. Thank you.
Thank you. Ms. Donahue?
Thank you, Madam Vice Chair. Ladies and gentlemen of the committee, my name is Kelly Donahue, and I am a trial lawyer and a member of the Maryland Association for Justice. I would ask for an unfavorable report on House Bill 25. And I just want to sort of take a step back here for a second. This bill is a huge ask on the part of the hospitals. And before we have a dialogue about whether the bill is constitutional, appropriate, inappropriate, I think it's really important to also take a look at the tremendous number of liability protections that are already afforded to the healthcare industry in negligence lawsuits that are afforded to no other industry in any tort lawsuit. First, in order for any of us to bring a negligence lawsuit against a healthcare provider, we have to go through an administrative process. The medical care has to be reviewed by a healthcare provider who is board certified or acting under in the same or similar specialty. That healthcare provider has to attest that there was a breach in the applicable standard of care by the defendant. Those things have to be done before any lawsuit can even be filed. That doesn't happen in any other tortious setting. Even once we get past that point, there was a question by Delegate McComas about, well, could you have a healthcare provider from out of state, attesting to a case and certifying it? And the short answer is, sure, you could. But in order to certify a case, a healthcare provider must be able to attest to what is the applicable standard of care. So, if they don't know what's happening here in Maryland or in a different state, which I would prefer is probably not going to be the circumstance because COVID is something that has impacted all of us nationally, that healthcare provider would not be able to certify the case, and the case doesn't get to go forward. In addition to those administrative responsibilities that we have, just this last summer, the healthcare system had a huge win in the Maryland Court of Appeals, and the Daubert standard was adopted. It's an evidentiary standard. It's a more rigorous standard. It favors healthcare systems and other litigants who have deeper pockets than the kinds of plaintiffs that we represent. But under that standard, if a healthcare provider who is an expert in a legal matter such as this, lacks reliable methodology, reliable factual basis for their opinion, they're going to get excluded. And again, the lawsuit doesn't move forward. In addition, sure. There's a whole myriad of things that apply to healthcare providers only. Statute of limitations. The cap on non-economic damages is half as much for a healthcare provider as it is in any other tort setting. And now we have a huge ask where the healthcare system wants essentially what is blanket immunity across the board. And they can call it whatever it is, but that is what it is. It's blanket immunity where we are completely eliminating a checks and balances system where there is no accountability. And that's not a fair thing to do. And it's never been done in the history of Maryland. And the reason for that is because it's wrong. And I would ask for an unfavorable report. Thank you.
Thank you. Mr. Thronson?
Good afternoon, Madam Vice Chair, members of the committee. Patrick Thronson on behalf of MAJ. It is well known that preventable medical errors, which are the third leading cause of death in the United States, disproportionately affect communities of color. I've seen this in my practice. A majority of those that I represent are people of color, usually of low to moderate means, who have been harmed by medical care that is unsafe and sometimes simply appalling. This legislation would bar meritorious claims by current and future victims of unsafe medical care. In doing so, it cannot help but reinforce existing racial and economic disparities, further harming many of the people who are hurting the most. The Office of the Maryland Attorney General has resoundingly opposed this bill, stating as follows. This office regards the proposed expansion and extension of immunity as unjustifiable and likely to increase the harms Marylanders are suffering during the ongoing pandemic, with disproportionate impact on those in low income and communities of color whose vulnerabilities are documented in the Attorney General's COVID-19 Access to Justice Task Force report. The sponsors have stated this bill doesn't take away anyone's day in court, but under this bill, the time most recent victims of medical malpractice have in court would be just that, one day, at a hearing to dismiss the case. Would this body really be honoring our true healthcare heroes by recommending legislation that hurts the very communities many of those heroes have tried to protect? If we care about equity, if we care about racial and economic justice, we should not be passing this legislation, which will unquestionably impair those objectives. I urge an unfavorable report on HB 25. Thank you.
Thank you. Mr. Tully?
Good afternoon, Madam Vice Chair, members of the Judiciary Committee, and I also want to recognize the Madam Vice Chair from the Health and Government Operations Committee, who's sitting in as this bill is jointly referred, and also Delegate Cullison, the sponsor of this bill from HGO. Just to wrap up, I mean, I think you've heard from us all and about why this is a bad bill and bad public policy. We do have a small army of trial lawyers on this one because this isn't a COVID transmission immunity bill. This is a broad immunity that the healthcare providers are looking for, and that's been explained. There was a mention in Delegate Cardin's question, and it's true that the trial lawyers did meet at the invitation of Delegate Cullison and the healthcare lobbyists for the hospitals to talk about this bill and to see whether there was common ground or any way forward that we could find an agreement on. And what we proposed, because we heard that these healthcare heroes don't want to go to bed at night worried that they might be named as a defendant in a lawsuit. And so we offered an amendment. We offered an alternative way forward that would allow those doctors to avoid being named as defendants in lawsuits in a manner similar to the way that the Federal Tort Claims Act is implemented. No doctor, individual agent of the United States, no department in the United States ever gets named in a Federal Tort Claims Act case. It's always only the United States of America is the defendant. We could do the same thing with hospitals. Name the University of Maryland as the defendant. The University of Maryland would defend the case. They would be vicariously responsible for all the care provided in the facilities that they control. We offered that as an idea to go forward, and that was turned down because that's not what they want. I mean, the only conclusion from Ms. Kinter's response to Delegate Cardin's question is they don't want to protect doctors from being sued. They want to avoid all responsibility. And because the hospitals would still have responsibility, our offer was flatly refused. They want no liability, and to pretend, as they have, that this bill still lets you get your day in court. It still lets you get a chance at justice. It still lets you get, some hope. It's just not a fair representation of what this bill actually does. It's
Mr.
clearly
Colley,
proactive.
time's
It's clearly
up.
unconstitutional, and it's clearly unfair, and it should be unfavorably reported. And for that, I thank you all very much for your time and attention.
Thank you. I see one question so far. Delegate McComas.
Thank you, Madam Chair, very much. This is just for any of the panelists that can answer this question. I have heard a rumor, and I can't tell you exactly where I heard it, but I've heard it a number of times, that if a person has comorbidities, let's say you go in and you have a serious heart condition, or let's say serious cancer, you go into the hospital and God forbid you caught COVID and you die, that the hospital will put COVID on the death certificate instead of the underlying condition, which was cancer, and COVID just, push them over to death. So have you heard that, or does anyone know if that's true? Because evidently by putting COVID on the death certificate, the hospital will receive more funds from the federal government, I guess, or someplace. They get more money. I don't know if that's true or not, but I wondered if any of you folks would know. And I know it's not really on point, but I'm just kind of curious to know, because I asked the same question to the hospital folks and they said they never heard that. So.
Yeah, I don't think we are qualified to answer the question about what the doctor was thinking when he or she signed a death certificate under circumstances. So I think can't speak for everyone on the panel, obviously, but I would take a pass on that one respectfully. I don't think I have, other than to say, there's some medical literature out there about the reliability of death certificates generally being less than perfect. But beyond that, I can't comment.
Okay, thank you, Mr. Colley.
Certainly, Delegate. Thank you for your question.
And are there any other questions? The chair is back.
I got here in enough time for everybody to ask their questions. Are we out of witnesses?
Yep.
Right. Well, we want to thank you all very much for being with us today, and thank you very much. That concludes the testimony for House Bill 25. Appreciate everyone's testimony. I'm sorry I missed the last part, but I had to get pulled away for a second. That also concludes the testimony for the House Judiciary Committee today on the 3rd of February 2021. We will be back tomorrow with a slightly longer schedule, and we will see you then. Thank you very much.